দাদা দাদা 453 453 ওটা আগে নেবেন তো? ঠিক আছে, উপরে রাখা আছে, উপরেই রাখা আছে।
রাহুল মেনশন করবি?
না
today, Lordship, but the matter is not in the list, Lordship. If Lordship kindly keeps the matter at 2 p.m. and extend the
record is not there.
Lordship kindly keeps the matter at 2 p.m. today.
Record has not reached yet.
Lordship kindly gives direction because the interim order will expire today. Will
Maybe the officers have sent the intimation, but it was not reached. Where is the record?
Lordship,
It was in item bench number 2.
yes, I went there, I checked, but it is not there also. I have checked with that bench also, but it is not there. Lordship kindly gives direction the matter and keeps the matter at 2 o'clock, Lordship.
আজকে আনুন তাহলে কালকে দিতে আজকে যদি আসে কালকে দিয়ে দেব tomorrow
Lordship, by that time the interim order will expire.
today interim order
Yes, today is the last day.
till today interim order is there,
Yes.
so if I pass an order
Lordship, if
tomorrow then it might be no issue.
Lordship kindly keeps the matter at 2 o'clock. By that time,
Subject to the fact record has to be reached, otherwise how can I pass an order?
Lordship, then if Lordship kindly gives direction to the department to find
They have sent twice,
Yes, Lordship, I have checked with them. They are not at default, Lordship, but if
so the
Lordship
record has to be
kindly-
reached, otherwise
Because the interim order will expire today, Lordship. I have been coming here to and fro every day, Lordship. But
no, yesterday it was
yes,
mentioned.
so I have come, Lordship. I have spoken to them. I have
So come on tomorrow then, first up,
but
10:30.
tomorrow. The interim order is still today, Lordship.
Whatever tomorrow, what to be done?
It is still, Lordship.
I think the matter should be the record should be reached. Otherwise, how can we? You know the difficulty.
Yes, I sincerely bow down, Lordship. But if Lordship gives direction, I think Lordship may
The
some
matter may
effort
be
should be made.
listed. Very well, I am searching it out. If it is appears, then I will pass the. যদি রেকর্ডটা পান তাহলে সাপ্লিমেন্টারি দেবে নাহলে কালকে if record reach the supplementary will be prepared, otherwise tomorrow.
Then Lordship, I will come at 2 p.m.
Okay.
Grateful.
Lordship may be permitted to mention one matter. Restoration application of order dated 4th July 25, Group 1 land matter. I have served.
Name? Yes.
Yes, my lord.
Land matters, my lord. AOR is complete, my lord. What
I cannot hear you.
Two land matters, my lord. AOR is complete. Only for hearing I mentioned.
Okay.
Blood,
On the
may I-
same matter I am playing, my lord, but other land matter, then let it be appear in the list for hearing.
For inclusion in the list.
Yes, my lord, for hearing. Yes.
Blood, land matter, my lord, for restoration, my lord, pleadings complete.
Why restoration again?
Blood, it was dismissed, my lord, during COVID times, my lord. Thereafter, we had filed within time. Extremely great.
My lord, may I have my lord's kind leave to mention one matter for extension of time, my lord? Earlier determination, my lord had lordship. My lord had granted us leave to file one application for vacating the ex parte order by the tribunal. There were 2 weeks delay on our part, lordship. May this be included, my lord, for extension of that earlier order.
Madam, I
Passed
don't
by
have
my
the
lord.
determination.
No, my lord, but it was disposed of by my lord, this matter. So I am just praying extension to the time my lord had granted me, my lord, to file that application.
You have filed one can.
My lord, extension of time.
Extension of time.
My lord. My lord had passed one order directing us to file one application for vacating the ex parte order passed by the tribunal. That we had done already. And also to deposit cost. But we have filed that application. There was 2 weeks delay, my lord. So it was not allowed.
Section 5.
The section 5 also we have filed. Yes, over there. My lord, great.
mentioning
Deeply obliged.
Regarding item number 130, last motion may not be reached today, my lord. When it taken up next week, 22nd on 20th, are subject to your lordship.
Next week, 21st, it would be reached.
I am here, my lord. 21st, I am here.
Item number
130.
130. 130. 130. Last matter.
last matter.
What you want?
Can you take it up the next week, my lord?
Why? This is the
This is urgency is there.
all matters are urgent matters. Mr. Dhada. All are the motion matters. All are the motion matters, new motion matters. If every matter is upgraded like that, no matter will be taken up. If not reached today, it will appear Monday. What is the difficulty?
Monday may not be.
Monday we don't know what would happen there. Tuesday it would be appear.
No, I will do that, madam. Because Tuesday, all if will also take it up Tuesday. Tuesday may not be reached, madam. There is urgency, so I mentioned this, madam. Otherwise, I have a
If not reached today, it would be appear on Tuesday.
Tuesday mention, madam.
Not mention matter. What is the requirement mention matter?
So otherwise, madam, matter cannot be
Should be
reached,
reached.
madam. Cannot be reached,
It
madam.
would be reached. Not reached.
Reached, madam.
Then next Wednesday.
Next one is the mention, madam.
If not reached today or Tuesday, it would appear under heading mention matter on Wednesday. Twenty-third. 23rd. Okay.
My lord, I have mentioned
Diplo
for
pen.
My lord, kindly state for urgent hearing, my lord. My lord, this matter is pending since the year 2022, my lord, and the KMDA acquired the land of the petitioners without any prior intimation, my lord. And now they are faced to express the purpose of this acquisition, not following the proper.
Group 1 matters for the year
2022.
2022 for listing.
Yes, ma'am.
Yes.
They're mentioning for inclusion in the list, my lord, under heading motion. Group 1 matter.
Group 1 matter.
Yes, my lord.
Group 1 matter for the
Inclusion in
year
2016.
16. 2016.
Yes.
Why it is appearing under motion matter? Reading is not complete.
My lord, it is all three read petitions are analogous matter, my lord. And petitioners have jural relationship. And my lord, the matter is relating to de-acquisition.
I understand why it is pending since 2016 under the heading motion matter. What about the pleadings? Complete?
Pleadings. Yes, my lord.
Then why it will appear motion matter? It will be appear under the heading hearing.
Yes.
So why you mentioning this for entry in the motion matter? You take instruction properly.
My lord, inclusion under group hearing, my lord.
Hearing matter.
May be permitted to mention for group for inclusion in the list group 1 matter, my lord, hearing.
Call the list. Badal Das and others versus State of West Bengal. I am reading only the operative portions. After considering the entire materials, it appears that the instant deed petition is infructuous due to dissimilarity in pleadings and proof I find no justification in pleadings of fraud as raised by the learned counsel for the petitioner. It appears the matter in dispute is in respect of an allegation of 2007. Now, after more than 25 years, the petitioner's claim for interference by this court has no merit. Under the above observation, the writ petition disposed of. Connected applications are also disposed of. Next. Nakun? Nakun?
So there was a direction to file the written notes. Madam.
Please take down written notes of argument on behalf of state respondents be taken on record.
Petitioners
also file a written notes of argument. Let the same written notes of argument be also taken on record. Argument of this matter has already been concluded. Made CAB.
No.
9 থেকে রাখো। তারপর 10 days। Pass it over. Next. Report.
The state IPF for the patient, the state was supposed to file the report.
What? Error order. I cannot hand it over. The report is ready, but this is not the right way to hand it over.
Not in the form of affidavit.
This is not ready even. And rather, no. If I given it, should not be.
Okay.
So
I understand.
kindly give me a 1 week time. On the next Tuesday, I will come back and give it to your lordship. Is it a direction? May I just indicate only one thing? Is it a direction upon the state to file an affidavit to the extent?
A detail.
I am extremely sorry, Millard. Bother this.
Detailed report in the form of affidavit.
Millard, in that event.
Yes. You have to affirm it. Next week, Tuesday? Fortnight time.
I'll come back.
But I am opposing this prayer, not.
Not there.
And I'm not opposing the prayer.
It's not opposing the prayer.
I don't.
So it will be automatic.
Very.
I'm sorry, Millard. My
So 28th would be date.
Great.
Mr. Sengupta, learned counsel appearing on behalf of the state, submits that the report to the department has reached, but it was not affirmed. Concerning the submission, the matter be fixed on 28th of July 2025 under the same heading.
And I will also take the point of maintainability.
It was there.
Yes, that is there.
Next.
The same order may be passed.
Yeah. Honorable, sir. Same matter, affidavit?
My lord, we'll file it, my lord. Kindly grant us extension for 2 weeks, my lord. We'll file.
Similar order. Next,
I believe similar order. Yes, stated.
We are appearing.
affidavit is not ready.
My lord, not ready, my lord. We'll file it.
Similar order.
AO नहीं है, report है ना अपना. But we're not appearing. I don't think state is being represented.
Which for the state? Similar order. Sonal Sinha.
Sonal Sinha.
Yes.
I dare not oppose.
I am informed by her clerk, my lord, that she is engaged in courtroom number 35.
Actually, same order.
Similar direction.
Yes, madam.
Reply कब तक है? Reply कब तक? इसके बाद होगा.
Sir, Agarwala is there. Arjun Roy Mukherjee. Okay, pass it over. Next.
Same order as in item numbers, my lord. 13, 14.
Appealing for the state. My lord, there was a direction for filing affidavit, my lord. Not yet ready, my lord. I need some extension.
28th of July. Similar order. Next.
17, my lord, I am for the petitioner. My lord, I am an existing FPS dealer, my lord. I have challenged, my lord, vacancy notification under control order 2013, my lord, page 32. This is my affidavit of service, my lord. But the authorities are taking steps to dealing the ration card tagged with the petitioner with the, my lord, with the private respondents, my lord. এই পারমিশন পেয়েছে my lord, which is contrary to the order passed by the honorable division bench, my lord, interim order passed by the honorable division bench in Sitara Begum, order dated 6th August 2024, my lord, where the honorable court has directed not to delink any, my lord, the ration card from the existing, my lord, FPS dealer, my lord.
Give me the affidavit of service. Please take down. Affidavit of service filed on behalf of the petitioner is taken on record. Despite service, none appears on behalf of the state. That 1543/2020. state to file affidavit in opposition within 3 weeks from date. Reply exception by the petitioner within 2 weeks thereafter. Considering the facts and circumstances of this case, the state authority, state respondents are at liberty to proceed with the selection process. But so far as the license of the vacancy notification is concerned, the same shall not be issued till the disposal of the
appear on behalf of the state.
appeal
Your Honor.
pending before the learned division bench, being MAT 154.
154. I appear on behalf of the state, Your Lordship, in this matter.
You are appearing on behalf of the state.
Yes, Your Lordship.
Despite service none appears such a state raised strong objection at a protocol. Not to issue license till disposal of the MAT 1543 of 2020.
Yes.
Next. None appears. Pass over. Pass over. Next.
Lordship, I'm for the petition, Lordship, there is a direction to file reply, Lordship, but Lordship, reply is ready, Lordship, but I could not affirm this, Lordship, because the petitioner is. Lordship, great, Lordship.
Next. Not this week. 22.
I appear for the petitioner, my lord. On the last occasion when they had sought time to file affidavit. If your lordship sees, my lord, there's a mistake in the last order. If your lordship would kindly correct that as well.
Sonal Sinha and Asima Chakraborty.
But the last order also recorded accommodation sought for on behalf of the petitioner. That should be responded.
Time to file affidavit has been extended.
No, for if you yes, it was extended. But we have not received yet, my lord.
You have not received yet.
They have not served yet.
What is the issue involved here?
But we've challenged, my lord, the license issued in favor of respondent numbers, my lord, the private respondent.
Then the affidavit is required.
Yes, yes,
Have you served on the private respondent?
The affidavit of service should be there, my lord.
Yes, affidavit of service is there.
Your lordship will kindly correct, my lord, the last order also, my lord. It states that accommodation has been sought for on behalf of the petitioner, my lord. It should be respondent.
Please take down.
Kindly gives them a last.
In the order dated 24th of June 2025, in the first paragraph, at the place of petitioner, it should be read as respondents. Okay. Petitioner to respondent to the payment order. Full stop. Next paragraph. Time to file a report in the form of affidavit by the state respondent was extended on the earlier occasion. Today none appears on behalf of the state respondent. Considering the situation, let the matter be appear peremptorily on 23rd of July 2025 under the same heading. Full stop. The state respondent is to file the affidavit in opposition stroke report in the form of affidavit within the adjourned date,
Well, as a last chance.
unless which the matter should be proceeded according to law. Full stop. The petitioner is directed to inform the gist of the order to the learned counsel for the respondent.
For the respondents, but both.
Respondent. Only state respondent.
So kindly, my lord.
State respondent. State respondent. Court.
Well, item number 19. Password.
Yes. Mr. Dhara, what is this? Item number 19.
And it will be Bandhavati.
Yes.
Krishna. Super.
Rich? Rich?
No, I am happy.
Subrata?
Who is for the state? Have you served? Give me affidavit of service.
Affirmation. Gone for affirmation. My lord, I will not lordship give trouble much, then I will come. That you lord.
What is this? Yes.
Give me a minute. Give me 1 minute time for
Yes, yes. Take your bill.
from that building to this building. Kindly come to your lordship's order dated page 23rd May 2025 at page 110. Then I will lordship tell you very short the fact. Or your lordships can recollect it also. Can I read just the operative portion?
Yes.
Having considered the materials on record, it appears the petitioner is aggrieved for non-execution of the agreement by the concerned authority. He has been impaneled. It further appears the petitioner has failed to appear before the authority on May, it will be February 18th, not May 18th.
Okay.
18 February 2025, when the date was fixed for execution of the. However, the authority concerned has made it clear that the agreement can be executed on furnishing of bank guarantee. Since the bank guarantee has been furnished, the concerned department should have act according to the memo dated April 24, 25. I make it clear that as the state authority has decided they shall proceed to execute the agreement on furnishing bank guarantee as it appears for the petitioner has already furnished bank guarantee, this court feels it necessary to relegate the matter to the authority concerned for further decisions. That the instant it petition stand disposed of with that. Therefore, just background is this. From 2007, I was running the wheat mill.
Yes.
Then another term has come. Online application, I have been selected. I have been selected and I have been asked for to give the bank guarantee, etc. In the meantime, I was arrested in completely different case, not case under the EC Act. And I was in the jail custody. Then I made an application to the concerned special court, kindly allow me to give, authorize my wife, power of attorney.
To execute the
yes, that it has been done by the appropriate order has been passed. My wife within the time has sent the letters, I am not giving a lordship's trouble. Can I take it that it is there? And also said the bank guarantee. Now they have asked me that we deposit 5 lakhs. I have deposited 5 lakhs. Thereafter, this has been given. In the meantime, I have been released on bail. I am released on bail by 11th April, before the time limit, 18th February, before that.
Yes.
Now, then I made the representation, allow me to bank guarantee. Then they didn't give it. Then, they have asked me to extra give the BG, extra BG. That I have also been given. Then they were not said no. Then, I came before this court. Your lordships have held it. You have asked for BG, extra BG. After that, you should. I am not taking a decision. A decision may be taken. Now, what here they have done? Now, kindly come to
12th June 2025 is the first order, page 120. Your Lordship directed an authority to decide. Those who are in the respondents. Now, this is with reference to so-and-so, the government of West Bengal impaneled Mill. Here it has been, the petitioner was arrested by the enforcement director on 23rd November 2024. An allotment was tweet in favor of the flower was withheld from February 25. The petitioner stated that he submitted application for impanel so-and-so. Nodia inspected the petitioner to deposit the impanel fee and request bank guarantee. Because that's not very important. Kindly come to Millard. Decision with reasons. Considering the entire facts and circumstances and the submissions made by the petition number 2 and also the DCFS and Nodia, I am of the opinion that careful examination of every aspect is required. Hence, the following 3 members committee is formed. A committee has been formed by them. But there is no delegation of power. Since your Lordship directed someone to decide, he delegated to the 3 committee. Anyway, now what the 3 committee has said, now my Lord, kindly come to 3 committee is the next order, page 123.
Yes.
Kindly come to Millard the reasoning portion of the committee. Decision with reasons. See. Decision with reasons, your Lordship will find Millard from page Millard 124. From the extract of the report submitted by the committee, it is reasonably perceived by the understanding that in view of the pendency of the criminal case against the petitioner 2, that is the proprietor so-and-so, and the authority considers running of the public system may be jeopardized. If the instant farm is allowed to operate in the instant case, it is reasonably apprehended by the authority that since the proprietor of said mill, Millard kindly just skip over then the Millard. A court rule has been quoted. The said provision subclause 5 of clause 8 state government may not renew employment. My Lord, kindly empanelment. Renew is not a case of a renewal. It's a case of a fresh application. Renewal of a flour mill which has defaulted in a supply of atta of the state or has not been maintained the proper quality of atta or whose performance has not been satisfactory. I am not coming with that. Or any criminal proceeding are pending or have been initiated against its owner. This criminal proceeding means, Millard, under the Act and the rules and the form, criminal proceeding means the criminal proceeding initiated under the EC Act. I'll show to your Lordship. EC under the EC Act. Now, accordingly, the respondent so-and-so does the solemn hence the petitioner is not eligible for imprisonment as per the above mentioned provision. Now, Millard, kindly see this provision. What is the provision and what is there? Kindly come to Millard. No. Millard, kindly come to just 1 minute, Millard. 2024, page 38. It starts from page 38. Millard, kindly come to page. First is empanelment. See, Millard, the empanelment 5. Kindly come to empanelment 5, Millard, clause 3.5. The state government reserves its right without assigning a reason to 1, 2, 3. Empanel only those firearms which may consider are performing or would perform satisfactorily as per the provisions of these guidelines and control. Empanelment right is there. Empanelment is not for consideration that a criminal case is pending. Then kindly come to 4. Empanelment flour mill to do certain acts with the prior consent of the state government. These are the functions. Millard, I don't need. Kindly come to Millard 8. Validity, renewal, etc. of empanelment. That's at page 41. Millard, got it?
Yes.
Now, kindly see, Millard, every agreement of empanelment made in accordance with this guidelines shall be valid for the period of 1 year. The agreement, unless an application renewal is made within the period of validity. 5. Kindly come to 5. State government may not renew empanelment of a flour mill which has defaulted in supply of atta to the state government or its agency or has not committed the proper quality of atta or whose performance has not been satisfactory or any criminal proceeding or pending have been initiated against its owner, proprietor, person, director or designated persons. This is now I will qualify, Millard, how this is relates to only the essential commodities act. Millard, kindly come to just Millard, give me. Kindly come to Millard, page 51. Consequences of conviction. the owner, proprietor, partner, director, designated partner of flour mill, if convicted by a competent court for violation of an order made under section 3 of the act or for any other offences relating to public distribution system, shall be de-empaneled for the director. Therefore, my lord, first is conviction, then conviction for the violation of EC Act and the or order control order. Here no conviction has been done. But here I was arrested for a false ground on the PMLA Act, money laundering case.
Yes.
Therefore, these provisions are not at all applicable here. And Miller, kindly see another one clause, Miller, that I will finish it. Where is that? ওই যে যেখানটাতে সেই কন্ডিশনটা দেখেছিল পেজ yes, Miller, kindly come to page 70. In the form what I have to apply. But when I have made the application, there was no criminal proceeding. Whether the applicant was at any time convicted, any criminal case, an affidavit in the prescribed. Then Miller, kindly come to another one that your lordships will see affidavit, which has been annexed by them, page 71. That I have not been convicted by any court of India under the Essential Commodities Act 55 or any other criminal case connected with essential commodity at any time prior to the application. Therefore, this is clear. This is clear case. Firstly, no conviction has been done. You cannot do it. And case conviction only in a case of the arising out of the EC Act. Am I clear to you, Lord?
I understand.
And another paragraph I will show and finish. Can you see paragraph 32? These are the similarly persons, Lord, have been given this benefit.
The directors of flour mills or rice mills,
these are have been given.
They also given the
yes,
empanel.
Similarly placed.
Empanel.
Empanel, and they have been deed has been registered in their cases. The petitions in similar circumstances, some other flour mills, namely NPG rice mill, flour mill, Pirgo food processing, GP Agro product, South Chobis Pargana, Onkit India Limited, Howrah, are allowed to continue by the responsible authority and some of them were arrested with me also. They got the bail. Oh, they have got the bail with me. All they have got the bail with me. ওই জাজমেন্টটা দাও তুই আছিস ওই বিবেকানন্দ কই ও আচ্ছা আরে জাজমেন্ট দাও
yes,
ওই জাজমেন্টটা যেটা কালকে দেখাচ্ছিল কোনটা করছিস কেন চ্যাংড়া মারতে আসিস নাকি কোর্টে সব বাজার নাকি কোর্টগুলো নিজেই দেখালি আমি বললাম রাত কালকে দেখাবো law is settled. If earlier also your lordships have sent them to do it, they have not done it. Now this order is completely illegal. And completely kindly direct them to give it. That 87 I have cited various times. It is Jagat Auditor General and Comptroller General case. Can remember that right hand side that before
yes,
the last two paragraphs it is there.
I understand. That's all?
That's all, Miller.
Yes,
But with your lordship's leave, can I go?
yes.
I have other matters going on.
Only issue is that
Yes.
paragraph 32. Whether
Yes.
you have considered the other person's
My
proposal.
lord, yes, my lord, we can come to that, but my lord, before that, my lord, I would, my lord, with your lordship's, my lord, leave, try to place the provisions in a different perspective.
Yes,
Lord, can I just?
yes.
Okay.
Yes, proceed.
Yes. So, my lord, to begin with, my lord, I am today before your lordship to argue on what appears from the face of the records before your lordships. My lord, unfortunately, in this matter, the instructions have not yet been received. But, my lord, from the petition itself, and my lord, the control order or the guidelines rather are also annexed. Now, my lord, may I start from the top, my lord, that what happened is that he says that he was empaneled, thereafter arrested, thereafter he spent time in custody. While he was spending time in custody, my lord, he could not, my lord, execute an agreement. But there is also another thing to it. If I may, my lord, will kindly comes to page 108. 24th of April 2025 is a letter by the District Controller FNS Nadia to my lord the petitioner.
Yes.
Yes. So, my lord, may I read from here? In consecution of the petition, it reveals that you are very much eager to execute the agreement in relating to production of PDS ATA, but as per notification of the empanelment of 4 mills dated so and so, the provisional allocation of wheat in favor of your mill is so and so per month, that cost of wheat is so and so. In this regard, bank guarantee required is, my lord, 2,63,21,827 and 44 paisa. That is the bank guarantee he should have had, my lord, produced. And, my lord, under the rules, I can also show your lordship the provisions, my lord, that it should be, my lord, subsisting till 3 months after the period of, my lord, agreement, so that claims can be made.
Yes.
Very well, my lord. Now, my lord, it says in the last paragraph, my lord, I'm sorry, my lord, in the next paragraph, it is disclosed in your letter that you have submitted all the required bank guarantees, but the fact is that out of 4 bank guarantees, 3 bank guarantees are expiring on 9/3/2026. Means prior to the date of expiry of the agreement, that is on 31/3/2026 in question. So, my lord, the bank guarantee though was given adequately, but it was not for adequate time. That is why, my lord, what we say is the bank guarantee you have bank guarantee with desired validity period is so and so. In view of the above, my lord, what I ask of them is that please provide fresh bank guarantee for the time required under the guidelines. Then, my lord, what I say is most important. On receiving your proper and required bank guarantee, this office will be able to initiate the processing of execution of agreement. That is, permission will be sought from department as last date of executing agreement was already over on 18th February 2025. So, my lord, I do not say that I will execute the agreement. I say that I will have to seek permission because your time is over. You have no right. I will also show your lordship, my lord, I will try to, my lord, content before your lordship that empanelment by itself does not create any right. My lord, it is almost akin to a name being included in the select list of a selection process, where, my lord, the only right, if at all any, is to be considered for being appointment.
Yes.
Unless you are appointed, there is no right. Very well. So now, my lord, let me, my lord, take your lordship. And, my lord, before I take your lordship to the provisions, my lord, may I draw your lordship's attention to page 110, which is your lordship's orders only. My lord, in the previous round.
Yes.
So, my lord, and I will come back to this again, my lord, after the provision, but just to, my lord, refresh your lordship's memory. My lord, may I draw your lordship's attention to page 112, last paragraph, because that is the meat of the matter, my lord. Having considered the materials on record, it appears the petitioner is agreed for non-execution of the agreement by the concerned authority. He has been empaneled. It further appears that the petitioner has failed to appear before the authority on May 18, 2025.
February 18. It will be February 18.
Yes, my lord, the date, my lord, has, because he was in custody, the previous letter, my lord, only, sir. February 18, 2025, when the date was fixed for execution of agreement. However, the authority concerned has made it clear that the agreement can be executed on furnishing a bank guarantee. Since the bank guarantee has already been furnished, and he did furnish,
the concerned department should have act according to the memo dated April 24, 2025, which is, my lord, seeking for permission of the higher authorities. Not to, my lord, had also not directed that the agreement should be entered into, and quite rightly so. Now, my lord, what your lordship proceeds to do is, I make it clear that as the state has already decided that they shall proceed to execute the agreement, my lord, though, my lord, there was no such, my lord, but that nothing turns on it because, my lord, this is not a positive direction. On furnishing bank guarantee, and this appears petitioner has already furnished bank guarantee, then comes the positive direction by your lordship. This court feels necessary to relegate the matter to the authority concerned for further decision. Now, my lord, the decision has already been placed before your lordship once. Yet, my lord, I draw your lordship's attention once again to 123. So, my lord, up to this stage, when I go on to proceed to decide, that is, my lord, strictly in accordance with your lordship's directions, because your lordship told us to decide the matter upon taking everything into consideration. So, my lord, this decision, it has been placed before your lordship. May I, my lord, place it again and say, my lord, that first thing which, my lord, has been pointed out by the learned senior counsel, my lord, appearing for the petitioners is, I relegate the matter to a committee. Problem is, my lord, he says that your lordship had not directed it. I say nothing turns on it. Why? Because that relegation was not for decision. That was for assistance on facts or maybe some suggestions. I am, my lord, entitled to take into account as the decision-making authority, my lord, under directions of your lordships, to take into account all relevant facts and all the laws. In fact, this is my duty to take into account. And for that matter, if I direct my subordinates or my colleagues to help me with the facts and, my lord, the law on this, my lord, that is not a dereliction of the orders passed by your lordship, my lord. I believe, my lord, your lordship will be one on this with me when I say this. So this is not an infraction. This is not a sub-delegation of a delegation, which I could not have had done. It is not a case that I have not applied your mind when your lordship wanted me to apply my mind. I have applied my mind, and, my lord, secondly, I have applied it and have ensured that I apply my mind to all relevant facts and all relevant law, for which, my lord, I only give the duty upon my colleagues or my subordinates to appraise me with everything, in case nothing misses by, my lord, attention. So this is not an infraction of your lord, my lord. I believe, my lord, your lordship will, my lord, find merits in this submission. Now, my lord, what I go on to ultimately do is that since a criminal case has been initiated or pending, my lord, I say, quoting rule, quoting, my lord, clause, if I may say, of the guideline 8, subclause 5, that I will not be able to renew it. I will not be able to renew it. Now, my lord, let us see, it has been, my lord, vigorously argued, my lord. I had, my lord, come in late, but I could understand the tenor of the argument made by Mr. Bandopadhyay, learned senior counsel, that he says that it is only, my lord, with regard to an offense under the, my lord, Act or the control order, whatever it is, my lord. Now, the case is not so. The case is not so. My lord, may I begin from the last thing, or the one of the last things which Mr. Bandopadhyay had pointed out. My lord, Mr. Bandopadhyay had taken your lordship's attention to, my lord, just, my lord, may I just, page 51.
Yes.
Consequences of conviction. My lord, I say it has got no manner of application in our case. It is not my case that he has been convicted, that is why he should be de-empanelled or not empanelled, or an agreement shall not be, my lord, entered into with him. Conviction has got nothing with pendency of a proceeding. Number one. Number two, my lord, from the bottom again, my lord's attention was drawn to, my lord, page 70 of this, 71 of this application, which is a form I need to submit.
Yes.
My lord, clause 2 was submitted that I have not been convicted by any court of India. No manner of application. My lord sees the next clause which was not placed before your lordship. That no criminal proceedings are pending or have been initiated against me or the flour mill or its owner, proprietor. So pendency is another ground, or designated partner under EC Act. My lord, I will obviate this under EC Act also. But pendency is also another ground. I am not on conviction, I am on pendency. My lord, the next, no criminal proceedings are pending or have been initiated by the Food and Supplies Department or its officer against the flour mill or so and so director or designated partner, that the statements made in above paragraphs are true to the best of my knowledge and belief, so and so forth. So, my lord, this will go on to substantiate that without conviction also, my lord, it can have effect only if it is pending. Now, my lord, will kindly take up the my lord, guidelines which will appear at page 38.
Yes.
My lord will kindly, my lord, comes to my lord clause 3, empanelment of flour mill. May I read from here, my lord? I would,
Yes.
my lord, with your lordship's leave, go a bit slow on this. With a view to control the production and distribution of atta through the public distribution system amongst different categories of ration card holders, the state government may empanel flour mills in the district of the West Bengal in the manner laid down herein below. So it is on empanelment. There are two things, my lord: empanelment, agreement. Empanelment, agreement. His refusal, our refusal, is that on the ground of agreement. I will not enter into an agreement with you. An agreement, my lord, your lordships knows, has to have consensus addendum, and that consensus cannot be forced upon by anybody, and that consensus cannot be against the law or the spirit of law. That is also there. I will come to that, my lord. I'll take a bit of your lordship's time on this, my lord. So, my lord, distribution of public distribution amongst the different categories of ration card holders, the state government may empanel flour mills in the district of West Bengal in the manner laid down hereunder. The state government may by notification invite applications from eligible flour mills for empanelment for the purpose of so and so, my lord. Thereafter, 2, there shall be no application fee for applying for empanelment of flour mills for conversion of wheat into atta, but each selected flour mill shall have to pay a non-refundable empanelment fee of 5 lakhs before execution of the agreement. Before execution of agreement. That is, so the sequence is empanelment, deposition of 5 lakhs, then agreement. And this is very important, my lord. This will, my lord, reflect upon reading of the, my lord, further provisions of law. My lord, may we now come to clause or subclause 4. Subclause 4 of the same clause 3. Any mill which was empaneled earlier and has defaulted in supply of atta to the state government or its agency, or has not maintained the proper quality of atta, or whose performance has not been found satisfactory, or any criminal proceedings are pending. Any criminal proceedings are pending or have been initiated against the flour mill or its owner, proprietor, partner, director, or designated partner under EC Act, or any criminal proceedings. So criminal proceedings will not appear twice. Once it is qualified by the word under EC Act, thereafter it is not qualified by the words EC Act. Or criminal proceedings are pending or have been initiated by the department against the flour mill or its owner, proprietor, partner, director, or designated partner shall not be eligible to apply for empanelment. So once it is qualified by under EC Act, another time it is not qualified by EC Act. So it can be a criminal proceeding under any act. That much I have been able to substantiate before your lordship, my lord. I will also show that this proceeding may not be even at the instance of the department. That is also contemplated over here. Reading further, my lord will kindly come to, my lord, subclause 6. Mere submission of application and or fulfilling the eligibility criteria and or deposition of empanelment fee, which is post empanelment, or renewal fee does not make a flour mill eligible for employment, empanelment or renewal. So, my lord, when does somebody even begin to, my lord, think of depositing empanelment fee? Once he is empaneled, but it says that it will not create any right in his favor. You are empaneled, you deposit the fee, you can claim no right that now you will have to mandatorily enter into an agreement with me. That is very clear. And it can also not be argued, my lord, if I am the devil's advocate for 1 minute and say that one can come and argue that no, it says that even deposition of empanelment fee will not entitle you for empanelment. Can't be. It will have to be read as will not create any right in my favor for agreement. Why? Because empanelment fee comes after empanelment. It does not create any right. For what? Agreement.
Yes.
My lord, my lord, read this subclause 6 with, my lord, subclause 2 of this clause 3, where, my lord, I had previously pointed out that, my lord, non-refundable empanelment fee of 5 lakhs before execution of agreement. So even if I deposit 5 lakhs, that also does not create any right in my favor. Ergo, I cannot claim a right of entering into the agreement. At that stage also I can be stopped. That is the contemplation of the guidelines. So, my lord, if we move on, my lord, to the Next, my lord, provision, which is clause 7. As I had, my lord, previously, my lord, submitted before your lordship just a minute back or 2 minutes back, that it is akin to selection in an, my lord, recruitment process. Name in select list does not create any right except for maybe treated in accordance with law for appointment.
Yes.
My lord, will keeping that in mind, my lord, will read 7. 7.1. The selected flour mill. Selected. The selected flour mill shall enter into an agreement clearly mentioning the duration of agreement so and so. So, my lord, empanelment is selection, thereafter comes agreement. And I have already shown that it does not create any right even if you have deposited the empanelment fees. Yes. The empaneled flour mill has to deposit a, the empaneled flour mill has to deposit a security deposit in the form of bank guarantee. My lord, this, my lord, I had already said, my lord, which will have to, my lord, subsist even after 3 months. My lord, he did not do that. Then, my lord, will kindly come to 8. Validity, renewal, etc. of empanelment. Every agreement of empanelment made in accordance with these guidelines shall be valid for the period of 1 year. Agreement of empanelment. So merely if your name features in a list does not create right. It will have to conclude with an agreement of empanelment. Otherwise, no right, except for being considered in accordance with law, exactly your lordship's language in your lordship's order. Will consider in accordance with law. Your lordship had directed that. Yes. So, my lord, kindly comes to the next subclause. The respective district controller of food and supplies with prior permission of director may renew the empanelment and execute a fresh agreement. So, my lord, empanelment at every stage, empanelment is by in itself nothing unless it is coupled with an agreement.
Yes.
And is mandatory, conjunctive. There is no, my lord, option of either empanelment. All right, I don't need to enter into an agreement with you. Your name is empaneled, so I will proceed to do business with you. No, agreement is mandatory. And, my lord, if we go back to clause 1 for 1 minute, my lord, every agreement of empanelment made in accordance with this guideline shall be valid for a period of 1 year. The agreement, unless an application for renewal is made within the period of validity, shall stand terminated after the expiry of the validity period. So, my lord, the validity is reckoned from the date of signing of the agreement.
Yes.
So, my lord, the agreement is the most important thing which creates right, not empanelment. Otherwise, it would have been reckoned from the date of empanelment. I would have been able to, my lord, give him work, everything, my lord. It is reckoned from the agreement. My lord, clause 5 thereafter, I'm sorry, my lord, the subclause 5 of clause 8. State government may not renew empanelment of a flour mill. This is important. State government may not renew empanelment of a flour mill which has defaulted in the supply of atta to the state government or its agency, or has not maintained the proper quality of atta, or whose performance has not been satisfactory, or any criminal proceedings are pending or have been initiated against its owner, proprietor, partner, director, or designated partner, full stop. There is no qualification. Neither under the EC Act nor by the department. It can be a criminal proceeding under any act by anybody. This is, my lord, what I was submitting of earlier, that this very guidelines contemplates that a person cannot be empaneled if a criminal proceeding has been initiated or pending and thereafter it does not qualify.
Yes.
And now, my lord, kindly comes to subclause 8 of the same clause. The flour mill as may be renewed for, I'm sorry, my lord, the flour mill as may be renewed for empanelment herein under shall have to execute an agreement again for the renewed period. Mandatory. Agreement is mandatory, otherwise, my lord, there is no right. Empanelment only, my lord, maybe if at all creates any right in their favor, is to be considered for being entered into agreement with them. They are at that juncture. So, my lord, now, my lord, kindly comes to clause 22. But before that, my lord, I will submit one or two things before your lordships, my lord. This bar of empanelment in case of pending criminal proceedings, my lord, I have been able to substantiate before your lordship that it is not qualified by any other words, my lord. It may be under any act by anybody. Now, my lord, why is this provision there? There must be a reason. There must be a reason. Why? Just to punish? No, a man cannot be punished twice or before his crime is, my lord, proved.
Yes.
My lord, the reason probably is, my lord, to prevent disruption. If a man who runs this business is taken away in custody, and my lord, I will show that there is chance that he may be taken in custody again. The order itself says that. This will cause disruption. And my lord, the whole, my lord, this infrastructure, these laws, everything is targeted towards the benefit of the public. That reigns supreme. I will have to keep that in mind. Now, my lord, keeping that in mind, my lord, kindly reads, my lord, 22, clause 22. If the state government, having regard to the conditions prevailing in any district, considers it necessary or expedient so to do in the public interest, it may by order exempt or relax subject to such conditions or restrictions as it may deem fit and proper, such class or classes of millers in the district as it may specify in the order from the operation of all or any of the provisions of this procedure. So, my lord, despite pendency of criminal proceedings, somebody, my lord, can be allowed to continue. However, my lord, there are two conditions to this. Number one, why? The intention is to subserve the public interest, not the interest of the person concerned. Public interest, number one. And number two, the discretion lies absolutely with the state government. That is probably why, my lord, your lordship had directed the state or the officers of the state to arrive at a decision. And we have so arrived at a decision. As far as, my lord, others being, my lord, given the benefit, it will have to seen in case-to-case basis.
Yes.
Number one. Number two is the discretion which has been applied by the state government, if at all. My lord, I am sorry, my lord, that I am not on instructions today on that, because that is a factual instruction. If your lordship so desires, I can come back with that. But the reasons which transpired, if at all, then, my lord, they have to be seen separately. Just because he has been given, I will also have to be given. No. The discretion lies with the state government. The, my lord, exercise of discretion will also be done to be have to be done by the state government. My lord, the only thing of challenge can be the exercise of discretion is, my lord, either vitiated by malice or, my lord, based on, my lord, something which is not relevant.
Yes.
Or, my lord, beyond the law.
It has to be looked into whether it is in public interest or not.
Yes. This is of course in public interest. Why? Because disruption. And, my lord, I will also move one step further to submit that there cannot be any, my lord, lack of bona fide on my part. Why? Because the first letter which I had, my lord, placed before your lordship, he had failed for any reason whatsoever, not attributable to the state. He has failed within 18th of February. Even then, I tell him that since you have told me, it seems that you are eager. I not only let him get over that failure of cutoff date, I also point out to him that he did not give the bank guarantee properly. I could have had right away rejected on that ground. I did not. I showed my bona fide. Fine, you give the bank guarantees, tell me that you have given, then I will escalate the matters with my department so as to, my lord, get permission for agreement. This is what we were on.
Yes.
There is no lack of bona fide. So, my lord, number one is, by referring the matter to a committee, I did not go beyond the scope of your lordship's order, because the referral was not for decision. It was not a subdelegation of the delegation. No. It was for appraisal of facts and law. Number two, my lord, my decision is in accordance with law. Why I say this is because, number one, the empanelment or the bar on empanelment has been rested on pendency or initiation of criminal proceeding, which is unqualified, absolutely can be under any law, can be by any instance, by any department. Number two. And, my lord, number three is that state government's discretion is there, of course, which your lordships had, my lord, allowed us to, my lord, apply. But the main aim is to secure the benefit of the public, which in our understanding we thought that will not be secured if we let him to continue. And my lord, probably I will not have to place the order of the district judge, the honorable subordinate court, my lord, before your lordship, which says that his bail can be varied or cancelled in case of, my lord, certain infractions which have been, my lord, contained in the order. So I cannot obviate the risk of he being taken into custody, or for other disruptions, the whole process can be disrupted.
Okay, I understand.
My lord, if there are any other, my lord, arenas on which your lordship would, my lord, want me to, my lord, assist your lordships, my lord, I stand for that, my lord.
Very good. Yes, Mr. Dhada, anything?
See, my learned friend said all the submission before the impanelment, after impanelment. Now you
Yes.
kindly come to the page.
My lord, before my lord, my learned friend, my lord, draws your lordship's attention, only one thing. I have time and again harped on this thing, my lord, that once empanelment is done, it does not ipso facto create any right, except for the right for being considered to be entered into an agreement. Now, my lord, I further say that even after empanelment, and my lord, I say that even after empanelment, my lord, I can raise my hands and say that I will not enter into an agreement.
After impanelment and after deposition of non-refundable fee, the
That
clause
will,
is 6.
yes, yes.
3 subclause 6.
My lord, that, my lord, does not compel me to enter into an agreement with a person empanelment of whom can tomorrow create disruption, and that has been prohibited by law right at the stage of empanelment, because this bar, as I have shown your lordship, empanelment agreement. We cannot play with words to, my lord, protect an alleged right which has not been given to him.
Yes, I understand. Yes, Mr.
Kindly come to the page 78.
Page 78. Yes.
This is the order for implement.
Page 78. Yes.
5th February 2025. Kindly to page 80. Page 80 bottom. The impanel floor means shall enter into an agreement with the district controller of food and supplies as per former prescribed by the state government. Copy of the agreement enclosed within 12 February 2025. This order issued by the Deputy Secretary,
Senior Deputy Secretary.
আমি যখন বলি যে ভাই তুমি তুমি যখন বলে তো তখন আমি কিছু বলিনি।
No, it is the
So sorry, sir.
You have impaneled. On
No,
the
no.
earlier occasion, you are also
No,
impaneled.
no, impanel. Then man,
Senior.
Admitted fact, you are impaneled.
page 82.
82. Yes.
District controller wrote a letter to me. In including above referred order, they are hereby informed that their farm will have been implemented by the Food and Supply Department. Now, as per direction of the department in the above referred matter, they are hereby requested to take necessary step for execution of the agreement. This letter create my right. My learned friend says only implement does not create any right. After 5th February order, this order has been issued by the district controller. This order created my right.
And that got extinguished on 11th February 2025 because he failed to meet the deadline.
ভাই আমাকে বলতে দাও।
Yes.
This order created my right. Now, my lord, in terms of the 25th February order, I deposit the fees on 10th February.
Non-refundable amount.
10th February. After 10th February, I move a application before the ED court. ED court granted me liberty to you executed a power of attorney in favor of your wife. You can proceed the. Then when I come to the district controller on page 84, he says I am not come within June. Then when I come page 84. 84, my wife laid a letter with the power of attorney and an order of the court and requested district controller to execute the agreement. Last date of execution agreement 18th February, not on 11th February. Last date of execution of agreement 18th February. I come within time. If district controller on 11th February inform my wife, you can deposit the excess shortage of bank guarantee, on that day I can deposit. On 11th February, I go to the office of the district controller with the power of attorney and order of the court.
Yes.
Last date of the execution of agreement 18th February. On that day, district controller can say so, that you can deposit the shortage bank guarantee. The district controller did not inform anything to me. After I released from bail, I wrote a letter. Thereafter, district controller wrote me a letter
24th of April.
24th of April. On the last occasion, earlier petition, your lordship consider this. After considering directed this. Therefore, I am not within beyond time. I come before the district controller within time. Had there been a case, I goes to the district controller beyond time, that I can understand my.
No, they have not denied your right to go to the agreement or otherwise in order in letter dated 24th of April. They have allowed you. They have allowed you to furnish the relevant bank guarantees, and they have said the matter should be again preferred sent to the department for execution of agreement.
Department not execute the agreement. Agreement executed by the district controller under the guideline. Department nothing to say. Under the guideline, the agreement should be executed by the district controller.
Now you see the letter. Permission will sought from the department as a last date of execution agreement has already over on 18th of February.
That letter, man, 24th April.
Yes.
What I am on, my lord, I am on 11th February. I goes before the district controller 11th February.
Now, I understand. Now, what is your submission?
No, my understanding said implement does not create two execution agreement. Their letter 5th February letter create right to me to execute the agreement.
Very good.
Now, my lord, come to the page 40.
Page 40. Yes.
Clause 7.
Clause 7.
Signing of the agreement and security deposits. The selected following means shall enter into the agreement clearly mentioning the duration of the agreement of the district controller. According to the pro forma prescribed by the state government within 15 days. My right create on 5th February. On that day, district controller issued the letter. I go before the district controller within time 11th February. Clause 17 create my right to execute the agreement after implement. Had there been a case after implement order issued by the government, district controller did not issue any letter. Here, man, district controller issued a letter directed me to deposit the security money. Thereafter, clause 17 create my right to execution of the agreement. I also go within time 11th February and before the district controller to execute agreement. Because my last date was 18th February, not 11th February. On that day, district controller can inform my wife, you can deposit the shortage of bank guarantee. I can deposit it. Next paragraph, clause 72, say clause 7(2). The flour mill designated partner shall submit the valid bank guarantee. That bank guarantee, what amount should be decided by the each flour mill, was decided by the state government on 12 February. District Control retained me to data to execute within 11 February. But what amount should be deposited in tune of bank guarantee, that was decided by the state government on 12 February. Now, come to the page. Page 90. Yes, madam. 12 February. Amendment in clause 7 has been amended. Then my lord, come to the for subclause 3, substitute the following subclause. The flour mill owner, proper director, designated flour mill shall submit bank guarantee 60%. Earlier my lord was 50%. After when the tender was floated, then there was direction for 100%. Now after that there was a meeting in the chamber of the principal secretary. Issued order on 12 February. All the selected flour mill, implement flour mill should deposit in tune of 60% bank guarantee. How can a district controller say I should agreement within 11 February? In terms of 12 February, district controller should have said to my wife, you deposit 60% bank guarantee because of last date of last date was 18 February. Now, next page 91. Here, execution of agreement extended till 18 February. I goes before the district controller within time. He should have told my wife, you deposit shortage bank guarantee, because shortage bank guarantee deposit order issued by the secretary on 12 February. I go before the district controller 11 February.
Mr. Thad, I understand these are the merit of this matter, but what is your submission regarding the denial of your right under clause subclause 5 of clause 3? They have denied your
8.5.
8.5.
No. Come to the page 41.
Yes.
Kindly here page 40 again, madam.
40.
40 clause 7 created right to selected parliament to execution of agreement with the district controller. Agreement has to be entered into in terms of clause 7, not 8.
Yes.
Every district controller agreement has to be entered into under clause 7. Then I'll come to the page 8. Clause 8 says validity, renewal, etc. of implement. Then we'll have 8.1. Every agreement of implement made, my lord, in accordance with this guideline shall be valid for a period of 1 year. Agreement should be executed in terms of 7, not 8.
Yes.
Here, the agreement, unless application for renewal is made within the validity period, shall stand terminated after expiry of validity period. Then when after in terms of the clause 7, agreement was executed for 1 year. If I not made an application for extension under clause 8.1, then minor agreement will be invalidated.
Yes.
Then we'll come to the 8.5. The state government may not renew. I am not here for renewal. Had there been a case, I am come for your lordship for renewal. They refused to renew my agreement. I am not come for renewal of the agreement.
Yes.
State government may not renew the impediment, not renew the impediment for a flour mill. But impediment comes when again notice has been invited. Renewal or agreement and renewal on impediment does not same thing. Impediment come when again invited application. State government may not renew the impediment of a flour mill which has default in supply of atta to the state government. Because I am not agreement. Or the supply of atta does not arise. Audit agency or has not maintained a proper quality atta or whose performance has not been satisfactory or any criminal proceeding. Well, here the criminal proceeding has been stated, that was defined. Come to the minor page 39. What is the criminal proceeding?
Yes.
Page 39. Clause 3(4). That was for impanelment. Any meal which have been impaneled earlier has been defaulted in supply to the state government audit agency or has not been maintained the proper quality of atta or whose performance has not been furnished satisfactory or any criminal proceeding or pending or under the EC Act or any criminal proceeding are pending or have been initiated by the department. Department means food department. Here Mena says the criminal proceeding that was should have been considered at the time of renewal of the agreement. I am not here for renewal of the agreement. Now my lord come to the day himself. Page 71. Affidavit. When a person apply in terms of Form K stated whether the applicant has any time convicted any criminal case. Next, my lord, an affidavit in prescribed form annexure I of Form K. That's my lord, page 71. Now my lord, page 71. 2. 1. I am the Indian citizen. That I am not have been convicted any criminal court of India under the Essential Commodities Act or any criminal proceeding connected with the Essential Commodities at any time part of the applicant. No criminal case proceeding are pending or have been initiated against me or the flour mill or its owner, proprietor, partner, director or designated partner under EC Act. That no criminal proceeding are pending or have been initiated by the Food and Supply Department.
Yes.
Then when I lastly when I come to the page 51. Non-execution of agreement means government after my implementation, the implementation. Then clause 29.
That is consequences of
Conviction. The owner, proprietor, partner, director of flour mill, if convicted by the competent court of valuation under the EC Act or any other offense relating to the public system shall be de-implement by the director. Today I am impaneled. Non-execution of agreement means director by order de-implement me, people convicted me.
So in this case, it was not conviction is there, no conviction is there.
But therefore, my lord, has to be executed by agreement.
Okay.
Had there been a case for renewal, I can understand, madam.
That's all?
That's all.
If your lordship permits me, may I quickly clarify?
Reply.
হ্যাঁ, তুমি নতুন
Then
point
what?
দিলে তো।
না, নতুন পয়েন্ট কিছু নিইনি আমি।
Yes, yes,
যা
yes.
ছিল রিট পিটিশনের বাইরে কিছু বলিনি আমি।
No, you had not submitted on these points, no. I have given you a reply on law. If your lordship allows me, I will. Otherwise, I won't. Because there is a new thing he has said.
New
with
thing.
regard.
I am not filing any supplementary affidavit. I am not filing any supplementary
Okay, very well, I understand. No, not the case, not the case.
My lord, this is with regard to my lord the letter of the wife. He has not produced it in this the correct light, and it was not produced by the learned senior counsel or placed by the learned senior counsel during his first my lord arguments.
No,
I thought that they had abandoned that.
That was
Yes.
the matter of earlier proceeding.
Yes,
I have already considered these facts.
very well. And my lord, the letter anyway says that the power of attorney has, the letter says that the power of attorney has authorized her to enter and execute the agreement between so and so. These words cannot be found in the agreement itself, which is annexed.
Very good. Okay. Please take down. Thank you.
Now, power of attorney, the other way.
Petitioner was empaneled by the empaneled by the government of West Bengal for functioning his flour mill for conversion of wheat into fortified atta for distribution to the NFSA beneficiaries of district Nadia. Full stop. After empanelment, while he was proceeding to execute an agreement with the department, the petitioner was arrested in connection with a case under PML, Prevention of Money Laundering Act, totally under Prevention of Money Laundering Act, and was in custody. Consequent thereto, he could not execute the agreement with the department, which was fixed to be executed on 18th of February 2025. While petitioner was in custody, he on the sanction of the learned trial court has executed an power of attorney in favor of a wife to execute agreement with the department. Full stop. The wife of the petitioner though approached to the department, but no such agreement was executed. Full stop. Petitioner, after releasing on bail, has applied before the concerned district controller for giving an opportunity to execute the agreement. On such, the district controller vide a memo dated 24th of April 2025 has directed the petitioner to furnish relevant bank guarantees so that he may approach the department for execution of agreement, as the last date of agreement has already been over on 18th of February 2025. Full stop. At this juncture, the petitioner approached this court in a writ petition. Full stop. In a writ petition being WPA number 11813 of 2025. Full stop. This court, vide an order dated 23rd of May 2025, has directed the concerned authority as follows. 112, page 112. Next para, in pursuance to such direction, District Controller Food and Supply. No, again. Director, Directorate of DDPNS, Food and Supply Department, read an order dated 12th of June 2025, formed a committee to take decision on that matter. Such committee has considered the case and passed an order on 25th of June 2025. Thereby, the committee, by referring subclause 5 of clause 8 of the concerned guideline of 2024, has observed that petitioner is not eligible for empanelment stroke renewal accordingly. His representation was rejected. Hence this writ. It is the prayer of the petitioner in the writ that the impugned order dated June 25, 2025 may not be given effect to. Full stop. Learned Senior Counsel, Mr. Bandyopadhyay, Learned Senior Counsel appearing on Mr. Bandyopadhyay, Learned Senior Counsel appearing on behalf of the petitioner, submit that initially submits that Director DDPNS has to take a decision on the direction of this court, but he again subdelegate the matter to a committee, which is illegal in the eye of law. It is further contention of Mr. Bandyopadhyay that criminal proceeding as referred in subclause 5 of clause 8 of the said guideline, 2024, means and includes only a criminal case pertains to an offense under section Essential Commodities Act. Full stop. He further submits that the petitioner was arrested in connection with an alleged offense under Prevention of Money Laundering. The respondent authority cannot deny his right for execution of agreement by showing such flimsy ground. Mr. Bandyopadhyay also referred me the relevant provisions of subclause 5 of clause 8 of the said guideline, wherein it appears that wherein he argued that this is in connection with new empanel, this is in connection with renewal of empanelment. He submits that the present petitioner was empaneled. It is not a case of renewal of earlier empanelment, earlier agreement. Thus, the clause 8 is not at all applicable. Full stop. It has also contended by the learned counsel for the petitioner that once a flour mill was empaneled and required bank guarantee has been submitted, according to the provisions of clause 7, the district controller has to execute an agreement within a specific period. Full stop. It has further contended by the petitioners that this court has considered the prayer of the petitioner and has directed the concerned authority to take a reasoned decision only in respect of execution of agreement. Full stop. The decision of the impugned decision of the authority is arbitrary. Thus, it is required to be set aside. Okay. Learned counsel appearing on behalf of the state submits that the direction of this court in WPA 11813 of 2025 has made it clear that the authority concerned has to take a decision on that point. Full stop. Director DDPS has formed a committee so that the decision can be arrived at properly. Full stop. There is no such direction by this court to pass an order in respect of execution of agreement by a particular respondent or particular authority. Thus, the decision of the director to create a committee to take a decision is not at all illegal. Question. Learned counsel appearing on behalf of the state further submits that clause 3 of the said guideline specifically made it clear that merely empanelment of a flour mill cannot ipso facto create any right in favor of the flour mill that an agreement has to be executed by the state of West Bengal in this case. West Bengal with all and every empaneled flour mill. He further pointed out subclause 2 and subclause 6 of clause 3 of the said guideline, wherefrom and whereunder he argued that there are sufficient opportunity to the state that before that after empaneling a flour mill and before execution of agreement at any time on the relevant reasons, the state is not binding to execute an agreement. It has further argued on behalf of the state authority that the petitioner was arrested in connection with a criminal proceeding during submission of affidavit. It has been clearly laid down that the flour mill must have shown affidavit to the effect that no criminal case is pending against him or against the flour mill or the owner or proprietor, partner, director. In this case, the petitioner was arrested in a criminal case, so the state has every authority to deny execution of agreement with the petition. Full stop. During course of argument, learned counsel for the Mr. Bandyopadhyay, learned senior counsel for the petitioner, has referred me paragraph 32 of the paragraph 32 of the writ petition, wherein it has been averted that See, in some flour mills, under similar standing under similar circumstances, were allowed by the state of West Bengal to execute an agreement. Full stop. Though the directors of those flour mills are also arrested in connection with PMLA case, and they were also enlarged on bail along with the petitioners. Full stop. It has been submitted by the petitioner that when the state has taken a decision in respect of other flour mills who were standing on the same footing, the petitioner may be allowed to be dealt with in the like manner. Like manner. Full stop. Repeating the contention of the of Mr. Bandopadhyay, learned counsel appearing on behalf of the state submits that clause 22 of the said guideline has empowered the state to exempt certain provisions of the said guideline in a special case. Full stop. Having heard the learned counsel for the parties.
Also that, my lord, I am not on factual instruction. It was only on whether it has at all been done or not. I am not on that instruction.
Okay. Furthermore, the learned counsel for the state submits that he has to take a proper instruction from the department to enlighten this matter before this court. Having heard the learned counsel for the parties, also considering the issue involved herein. In the first instance, when the petitioner approached this court in writ petition number 11813 of 2025, this court is of opinion that as the authority concerned has made it clear that agreement can be executed on furnishing bank guarantee. This court, on the basis of such memo dated 24th April 2025, directed the concerned authority to take a decision. Full stop. This court, while passing the order, has clearly mentioned to relegate the matter to the authority concerned. By this order, this court has not directed any of the particular respondent or particular authority to take a decision. The decision of the government has its own merit and prerogative. Who shall take the decision? Full stop. The decision of any of the authority of the government on that matter would be the decision of the government. I make it clear that this court has not relegated the matter to a particular authority. Thus, the decision of the concerned director DDPS to form a committee to take a decision is not at all appears to me illegal. Full stop. In considering the merit of the matter, it appears that the authority concerned has decided has denied to execute agreement with the petitioner by showing reasons as per provisions of subclause 5 of clause 8. Full stop. To understand the issue properly, let the clause 8, subclause 5 of clause 8 code to is properly clause 8. Let clause 8 of the notification of 2024 be set out as follows. Page 41, clause 8. অনেক বলতে হবে। apparently clause 8 dealt with the validity, renewal, etc. of empanelment. Full stop. Subclause 5 of clause 8 dealt with renewal of empanelment of a flour mill by the state government. Full stop. In this case, clause 3 would be more applicable regarding empanelment of a flour mill. Full stop. Of flour mill. Full stop. Clause 3 discloses, clause 3 discloses, bole, clause 3 টা set out kora. Applicable. It appears that the guideline of 2024, if read guidelines, it appears that if the guideline of 2024, 2024, especially clause 3 and clause 8 read conjointly, that means the state government has make it clear that if any mill which was empaneled earlier or which has applied for empanelment is entangled with any criminal proceeding in respect of EC Act or any criminal proceeding, if pending or have been initiated by the department against the flour mill or its owner, proprietor, partner or director or designated partner, shall not be eligible to apply for empanelment. Full stop. The specific provisions of the said guideline, though must have concluded with the provisions that there is a bar for a flour mill against whom a criminal proceeding is pending under EC Act. But it has also made clear in subclause 4 of clause 3 that pendency of any criminal proceeding is also a bar to empanel a flour mill. Full stop. In this case, though the substance of the submission of the learned counsel for the petitioner has no, though in the submission, no, though in this in this case, though the submission of the learned counsel of the petitioner had substance regarding the merit of the impugned order, but at this juncture, without giving the state authority to submit the affidavit, if an order as prayed for be passed, that would be tantamount to be the final order in that initial stage. Moreover, I make it clear that the state has to give an opportunity to submit in respect of paragraph 23 of the paragraph 32 of the read petition, so that the matter can be dealt with properly. I make it clear that the state must submit an affidavit on the point that why submit an affidavit on the point that why other flour mills who were engaged in the cases of who are entangled in the cases of similar nature to that of the present petitioner, why they are allowed to execute agreement with the state. Full stop. Under the above provision, the state authority is directed to submit an affidavit within 3 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Let the matter appear in the list under the same heading on 12th of August 2025.
My lord, may I just only one clarification? My lord, are we to submit affidavit in opposition or only an affidavit on that point?
Affidavit in opposition.
So, my lord,
along with all other points.
Will kindly clarify that, my lord, just to. And my lord, may we have, my lord, 4 weeks instead of 3, my lord. I am pitted against the one of the best in country, my lord. And also,
then 20th of August.
Extremely obliged, my lord. And we are having 4 weeks, my lord, probably.
4 weeks, 1 week. 4 weeks, 1 week. 20
August.
20th. 20 Wednesday.
Grateful, your lordships.
Next.
Earlier matter, it is passed over. I could not appear. Yesterday it was adjourned since private respondent.
Yes, which matter?
Yesterday, it was adjourned since private respondent did not appear. Your lordship asked me to ascertain whether he has received or not. I have taken the track record. He has received. I am praying some interim protection. Let it appear on the next week, but I am praying for some interim protection.
What is the matter? Item number?
Regarding the selection of FPS dealer.
Item
number 18, 18.
You are there? ठीक है, item 8 दिन तो pass over. Who is for the state? Have you served?
Malat, yes. This is the affidavit of service.
Why no one is appearing on behalf of the state?
Yesterday also nobody appeared.
What is the matter about?
Regarding the selection of FPS dealer.
Yes.
The selection criteria is there two part. First was the 100 marks regarding the assessment of fulfilling the criteria. Balanced the entire recruitment rules. And the second part is the selection committee, district level selection committee is there. They will consider the assessment of 75% and they will assess the suitability of the candidate by awarding 0 to 25 up to 25 scores. Thereafter, average marks, after the average marks, they will select the most suitable candidate. The specific clause is, if required, the authority shall take personal interview of selected candidate. Now, in this case, for the first part, the 75 score is concerned, fulfilling the criteria, the petitioner's apprehension is that they will get, both the petitioner will get much marks than the selected candidate. But in case of the interview, they have, without selecting the suitable candidates, they have conducted the interview and given extra marks to the selected candidates and he was selected. I prayed for, I made an RTI application as well as the application to show the details score sheet and the selection criteria. There is no reply. My only prayer, let them produce the entire original records, how the scores has been given, how they have assessed the most suitable candidate. And thereafter, if it is found that yes, she was the most suitable candidate, then I have no case. But if it is found that my score is high in the first part, but only to accommodate those candidates, in the interview, she has been given more marks than us, then I have some case.
So you have to show this code that
Yes.
you have scored the highest mark.
Yes, unless they produce the score sheet, my lord, I cannot. I apply.
I have to call for a report.
Yes, my lord.
I have to call for a report.
My lord. My lord.
So what you want, till then no order can be passed.
On the status quo only.
You are also not submitting anything before this court that you are the.
No, my lord, I cannot. I cannot because my lord, they have assessed. My lord, I applied. My lord, I have annexed the copy of the application.
Very well. I'm passing an order. Let the matter be appear on Monday.
My lord.
With a short report.
My lord.
Please take down. Petitioner applied for license in connection with an vacancy notification issued by Subdivisional Controller, Food and Supply,
Malda Sodor.
After the application of the petition be accepted online, his proposed shop cum godown was inspected by the concerned authority on 28th October.
My lord.
28th October 2024. Full stop. It is the thereafter he was called on a personal interview by the district level air price shop selection committee.
After spot verification, we were preliminary selected. Thereafter, call for interview.
Subsequently, it came to notice to the petitioner that his candidature was rejected. My lord. It is the contention of the petitioner that he is the most suitable candidate and had scored highest marks in the inquiry conducted by the SCFS concerned. It further submits that the act and action of the respondent authority in rejecting his candidature is illegal. Learned counsel for the petitioner further submits that if any candidate be selected by the concerned authority during that period, the entire writ petition will be frustrated. He prayed for an interim order. Full stop. Next one. Having heard the learned counsel for the petitioner, also considering the pleadings and materials of proof placed along with the writ petition, it appears that the petitioner has not placed any material or evidence before this court that he has received the highest mark by the concerned SCFS in inquiry of his proposed shop cum godown. Moreover, that has to be ascertained by this court. Moreover, that can only be ascertained by this court on the report of the state. Full stop. Despite affidavit of service, filed on behalf of the petitioner is taken on record. Despite service, none appears on behalf of the state. Full stop. Considering the situation, the state authority be peremptorily directed to submit a short report in connection with the impugned vacancy notification on or before on 22nd of July 2025. Full stop. The petitioner is directed to serve the copy of the order upon the state through government pleader, so that the state may be represented on the urgent date along with a short report. Mr. Dotto, are you there? You are not there.
I will communicate this order.
Okay. Let the matter appear on that.
But only reports status only to be maintained. Nothing else. Status quo as on.
No, if you have,
But they have only issued the offer letter, not appointment letter. Only issued the offer letter. If he give consent, then my appointment letter will be issued. The appointment letter has not yet been issued. That's why I'm praying status quo to be maintained. Nothing else.
You have an order of interim order.
My
you
lord.
must have shown something.
I applied under RTI Act to supply those documents. They have not supplied.
They have not supplied. That's why I have nothing.
Yes, my lord. Only status quo, nobody will be prejudiced. If a status quo is there, I am not praying anything else. Only status quo, nothing else.
Then Mr. Datta has to be appointed here.
Well, kindly engage, I shall supply copy,
Mr. Datta, you please appear in this matter. No one is appearing since yesterday on behalf of the state.
Somebody is
Already engaged?
Perhaps, perhaps. I can sub the copy,
Okay, okay, very. ठीक है. Having heard the learned counsel for the parties and considering the circumstances of the fact that an offer letter has been issued in favor of the private respondent, who was served, but none appears on behalf of the private respondent. Consequent thereto, there shall be an order of status quo till the adjourned date in respect of the vacancy notification. Full stop. The petitioner to comply the provisions to serve the notice in respect of the ad interim order.
I will serve to both the private respondent and
the all respondents.
Certainly, I shall serve. 22nd, your lordship fixes the matter on 22nd. Deeply obliged.
Item number 23.
I have a fixed matter.
My lord, kindly take up the item number 23 tomorrow, my lord, as specially fixed.
Tomorrow I have group 1 matter, you know.
My lord, I know, my lord, but my lord, since this is a review matter, my lord, kindly take up the matter, my lord, tomorrow.
Which matter?
My lord, 23, just
23.
23, my lord.
Tomorrow, how can I take up the matter?
Kindly take up this matter tomorrow, my lord, as specially fixed matter, my lord, tomorrow in the morning, my lord. Because, my lord, today at 2 p.m., my lord, several matters are there, my lord. So, my lord, I will not get the chance, my lord.
Let's see today what can be done. Okay, let it be there.
But today, my lord, several matters are there, my lord, 2 p.m.
I
matters.
do not know whether which matter will be taken up today. Otherwise, your matter will be taken up. If the two matter, there are how many matters? 1, 2, 3, 4, 5 matters. Okay, very well. Let it be there. No order. If not passed, I will pass the order after 2 p.m. Specially fixed matter.
I beg to appear, my lord, on behalf of the petitioner.
Okay.
Difficulty is the matter will not be concluded today. Is it your lordship's pleasure? It will not be concluded today.
Very
well. Other matters released for the time. Up to month.
No. Kindly wait.
Yes.
It may not be concluded today. And after 2, I am in difficulty.
Okay.
My lord, kindly fix it in the morning of any day.
Morning of any day. Okay. 10:30 you want?
Yes.
বলেন সঞ্জিতা জবে বলে আসলে স্যার আসলে
ডায়েরি
দেখেন
আরেক জন্যই তো 11:30 করতে
নিচ্ছেন না হাতে নিন 10:30টাও যায় অগাস্টে দেখুন অগাস্টে
জবে স্যার
4 তারিখ
কোনো দিন 10:30
10:30 আছে কিছু 4th of August 10:30.
Any day can be your convenience, but in the morning.
10:30.
Otherwise, my lord, I won't be able to conclude.
4th of August 10:30.
Grateful.
Okay. Please take down. Shokinath Mukherjee, Learned Senior Counsel, Learned Senior Advocate, appearing virtually, submits that the matter is otherwise ready for hearing, and he shall start hearing as a date be fixed by this court. Considering the submission of the Mr. Chandicharan Dev, Learned AGP, is also represent the state. Considering the submissions of both the parties, let the matter be peremptorily fixed on 4th of August 2025 at 10:30.
Grateful, Lord.
Okay, thank you. Call next matter.
আমি একটু পাঠিয়েছি
23
ওইটা
21 টাকা 23
21 হয়ে গেছে।
হ্যাঁ 23 হবে 21 কখন হবে? 21 টা কখন হবে?
21 হয়ে গেছে।
মানে 21
It was called,
সকালে called.
it was called and it was not this week.
Oh no.
Whereas petitioner was there to call not this week. It was already called.
The 23 to.
What is this matter?
The review matter. 23.
Review matter, have you served?
Yeah, one side here, ma'am. Okay. Well, there are two applications. One application for condonation of delay, my lord.
Can two.
Can two. Yes, my lord. Can two is application for condonation for delay.
And can one is the review.
Can one is a review for application.
And what is the application for appropriate?
My lord, may I please that can one first, my lord.
Yes. How many days delay?
95.
95 days.
Okay.
Well, let the delay be condoned, my lord. And I, so that I may start, my lord.
What are the grounds?
My lord, my lord, since my lord, I am taking one. My lord, the judgment was delivered on 25th February 2025, and it was informed sometime in May 2025 by the learned advocate for the petition.
Okay.
That's why, my lord, immediately thereafter I took the certified copy, and then, my lord, I moved it.
Very good. Yes. What is the matter? What you want to review?
My review is this, my lord, that certain points of law could not be placed at the time of hearing of this petition. My lord. Your lordship has held that I was the fence sitter since I made application in 2022. But my lord, I being a married daughter of the deceased dealer, I was not entitled to make application till the amendment which was made in 2020. That provision was not placed for lordship, my lord. My lord, may I? The lordship will kindly come to page 20 of your lordship ordering person, my lord.
Yes.
On the facts and circumstances of this case, it appears to me that the writ petitioner is married daughter. The lordship will kindly mark, my lord, of the deceased dealer who not appointed for the license or compensation ground, rather filed no objection for some other applicants. They are not materialized. The present petitioner applied for license. In my view, there is a long delay in filing the application for getting compensation appointment. The status of the present petitioner can be considered to be a fence sitter who was consciously silent and observing the fate of the litigation. My lord, this is not correct, my lord, because why I could not make application, that was not placed before lordship, my lord. May I place the amendment, my lord? The amendment came in the year 1920. My lord, earlier, this was the law that unmarried daughter only were entitled to. Only unmarried daughter were entitled to make application. Then, my lord, the amendment came. Thereafter, this amendment came in 16 December 2020. Then
হবে না বোঝানো যাবে না
apply করব।
Yes, amendment.
This amendment came in 16 December 2020, where the daughter was included. Only by virtue of an order passed by this, a coordinate bench of this honorable court, married daughter was directed to be included, and then after this amendment came.
daughter including daughter legally adopted before death or incapacitation, divorced daughter, and widowed daughter.
All daughters, my lord,
Not
including
all
those.
daughter.
Oh, yes, my lord. That was married daughter. This was the judgment which was passed by this honorable court. Thereafter, this amendment.
Now, whether this when the amendment take effect?
16
That's the
December
material
2020.
question. That is the relevant question. December 2020. Law.
14 December 2020.
Yes.
This 16 December 2020.
Death occurred in 2007. Then widow applied, daughter-in-law applied, then the married daughter has applied.
No, married daughter is
This is
applied. my lord,
hereditary,
amendment.
as if it is hereditary.
My lord, the only submission to your lordship, my lord, that the definition of family member was changed in 2020. I came to know about that amendment. I was not a fence sitter. I was just trying to get my license. Initially, there was 2003 control order where the legal heirs could have applied. At that time, married daughter was not in the legal heirs. That's why I could not apply. I had to give no objection to my mother and my sister-in-law. Then, my lord, that application was rejected. I have nothing to say because I was not entitled to make application. Only after this amendment has come and I came to know about this amendment, I have made application. I am not a fence sitter.
No, whether your pleadings was there that after amendment I got the right.
My lord,
No
that
such pleadings were there.
My lord, that pleading was not there. I agree, my lord.
Yes.
But it is a point of law. Your lordship can appreciate that I may take at any time. This is a point of law, and your lordship, it was not canvassed at the time of argument. And that is the reason I have come for review. And my lord, there was pleading chilo.
Round number 20.
No, my lord, I stand corrected, my lord. My lord, that was not placed, but there is a ground. For that, in view of the notification dated December 2020, daughter has been included under the definition of family member. That was there, but it was not argued.
So your solution is that the word fence sitter upon the petitioner is harping. So you are not the fence sitter.
I was not the fence sitter. So
So
my right accrued, and I am entitled to be considered.
So when you applied for the compassionate
In
ground?
2022.
2022.
My lord.
Against the required 90 days.
Yes, I understand.
That is not mandatory. I am fortified with a judgment of division bench of this court. That is not mandatory period.
No, I am not going to the entire merit. I just want to know
Only my lord review I am seeking.
whether review
I am not a
whether
fence sitter.
within the limited scope of review or not.
I was not a fence sitter. And my lord, your lordship, if I am not a fence sitter, then your lordship will at least direct the higher authority to consider my case. Because my lord, the approval is to be given by the higher principal secretary, the state government, and the director has rejected it. But there is a judgment that it is delay is not mandatory. It is not mandatory of 90 days, madam.
সাইটেশনটা বলো আমি কি করে বুঝবো
আমি
আমি তো
দিচ্ছি
সব
আপনাকে,
জানি না।
কপি দিচ্ছি।
এটা কি কোনটা দেখাচ্ছ কি জাজমেন্ট বলো এটা
ওই যে 90 days is not mandatory.
নমিনেশন দিয়েছে জাজমেন্টটা দিয়ে আবার নিয়ে নিল দিয়ে দেখি আবার নিয়ে নিল।
Earlier it was 60 days, my lord. And that has been directed, it is not mandatory.
কনসিডারেশনের কোনো জায়গা নেই। প্লেস করে আমি তো বুঝতেই পারছি না কি জায়গা।
Need the discretionary power.
So far as section 5 is concerned, my lord, I am not opposing. But this, my lord, I have to oppose. And your lordship's order, if I may place your lordship's own order, review of which has been sought for, if I may place from paragraph 18, the recent order which was challenged is quoted here. Lordship, kindly have a look to page 18 once. I just, I'm putting this. আচ্ছা ঠিক আছে, 3 words of it.
Okay. The judgment which I have given to your lordship find that in this case, the appellant has tried to establish a very positive case that on the death of her son on 6 January 2016, she became ill as a result of shock. Intense grief suffered by appellant on the death of her son is quite natural. We believe this statement. We also accept that because of the intense grief, she could not file the application for appointment as a dealer on compensation ground within the time of 60 days. It took her 5 months time to recover from this day. On or about 9 June 2016, PR form was filled up by her.
What are you reading?
Page number.
Page is not paginated.
The judgment is not paginated.
You are reading from the portion of Justice Prokash Banerjee?
No, my lord. From Justice IP Mukherjee.
IP Mukherjee.
আমরা কেউ না বুঝতে পারি এমন ভাবে করেছো যে আমরা কেউ বুঝতে না পারি কোন পাতা কোন প্যারা।
Where the my lord judgments have been quoted thereafter, my lord. The last judgment in the state of Bihar. Has lordship got, my lord?
Yes.
The appellant had tried to establish the second paragraph. May I read it again, my lord?
Yes.
The appellant had tried to establish a very positive case that on the death of her son on 6 January 2016, she became ill as a result of shock. Intense grief suffered by the appellant on the death of her son is quite natural. We believe this statement made by her. We also accept that because of this intense grief, she could not file the application for appointment as a dealer of compassionate ground within the stipulated time of 60 days from death. It took her 5 months time to recover partially from this state. On or about 9 June, the TR form was filled up. Thereafter, signed by the sub-divisional controller, deposited the same. She submitted this form. To my mind, the intention of the legislature is most important. This intention may not be evident from the express word of control order, but the intention as sought to be identified by Mr. Bandyopadhyay on comparison of 2 control orders is most important. In the first control, that is, my lord, this is 2013 control order. Extending to a geographical area, the time limit is 60 days from death, whereas in the other control order, extending to another geographical area, there is no time stipulation. Both these control orders were issued by the staff. That means your lordship knows that there are 2 control orders. One is control order 2013 and another is urban control order 2013. This is the comparison of those 2 control orders. It is to be presumed that the government did not intend to discriminate between an applicant for compensatory appointment for dealership based on any region or area in which the dealership was situated. It is a settled principle of law that a scheme for compensatory appointment has to be applied strictly. To avail of the benefit of the scheme, an applicant has to satisfy its requirement. There is no scope of extra sympathy or compassion than what is provided in the scheme. But every stipulation in the scheme is subject to interpretation. In this case, the scheme is contained in the control order, which is a piece of delegated legislation. The provision regarding the time limit within which an application for compassionate appointment can be received by the government is also subject to interpretation. The interpretation required in this case is whether the application of the appellant filed on 27 September 2016, more than 8 months after the death of son, could be received. On consideration of two control orders, the intention of the legislature seems to be plain that the time limit of 60 days was for the purpose of preventing undue delay in the presentation of claims, or in other words, the purpose was to invite claim as expeditiously as possible. This is so because a vacancy in the dealership arises immediately on the death of a dealer. My lord, I pause here for a moment. In this case, vacancy has not arisen since 2007. Still the vacancy is there. No vacancy has been declared. If the dealer's family is in financial distress, he has a right to obtain the dealership. Otherwise, it is offered to the public. It is the responsibility of the government to allot the dealership through a selection process after the death of a dealer. Before doing so, the right of the family of the deceased to avail the compassionate appointment has to be availed of and dealt with as expeditiously as possible. In my opinion, that is why the time limit on a purposive and fair interpretation of the control order. In appropriate cases, the government retains the right to extend the time. In this case, after that case, and my lord, in those circumstances, it was not proper on the part of the respondent to have rejected the application of the appellant on the ground of delay. And my application has also been rejected by the director on the ground of delay. Now, my lord, judgment has more been dealt with by Justice Dida and Justice Prakash Banerjee, Pratibha Banerjee. The second page of Justice Pratibha Banerjee.
Yes.
This is because if a period mentioned in a provision having statutory flavor is mandatory, then where there is a delay of 1 day in complying with his requisition or 1 year, the effect would be the same. The filing would be null and no effect can be given to it. Yet, here not only the deed authority issued the petition PR form at least 4 months and 3 days after the expiry of the last date, the authorities accepted the requisite fee and did not refund it. Very curiously, there is no allegation by the authorities that this was a mistake. Therefore, this admitted position of fact and continues to haunt the contention of this one. Thus, even though there cannot be any estoppel against statute or that which has the effect of one, I may take it that an estoppel is operating against the respondent from disputing that the time period of 60 days is directly and not mandatory. If sufficient cause is shown, the authority would always have the liberty to condone the delay, as was done in this case for the widow who was mentally shocked at her son. But so the period.
This is not the issue here. Issue is that this is the merit of this matter. I shall not enter into that. Why what you want in the review application? What portion you want to review?
I want to review that there should not. I should be the fence. I am not a fence sitter. Therefore, and the application which was considered by the director only on the ground of delay, that should be set aside.
Now, once you have filed a no objection affidavit,
that
I have no objection. How you can come again that give me?
That's why I will.
There is any scope
because there was no other alternative in the earlier control order when the deceased dealer died. The dealer died. Then there was operating 2003 control order, and in 2003 control order, any one of the legal heirs could have applied with no objection of all others. So when my mother is applying, I have to give no objection because I am dependent upon her. But when her application was rejected and when my right accrued, then I had made application. May I place the 2003 control order, my lord? But at that particular time, this was in vogue. When I am reading out the list. In case of vacancy arising out of death, incapacitation on medical ground of an executioner, such vacancy on the prayer of the legal, in case of death or incapacitation on medical ground of an executioner, such vacancy shall not initially be notified. The prayer of the legal heirs, your lordship kindly mark, madam, will be considered with preference on compassionate ground, provided required minimum qualification are fulfilled. If out of several legal heirs, only one legal heir is the claimant, he is to submit no objection of other legal heirs along with prayer. My mother is a, I will
2003 controller.
2003 controller. And at that time it was invoked. That's why, my lord, I had to give no objection. And this application has been considered by the director under 2013 control order. 2013 control order, my right was not there. But that has not been criticized. What is the director has said, my lord, kindly consider only the delay on the ground of delay, it has been rejected. My lord, kindly come to page 12 of my application. Only delay, my lord. Page 12, last paragraph. On scrutiny of the case records and considering submission of the applicant in the light of the WBPDS Control 2013, it is found that the erstwhile dealer Vijay Kumar Mandal died on 12 July 2007. The applicant Kavita Mandal, married daughter of the deceased, did not apply for FPS license compensation ground within reasonable time. Rather, she furnished a declaration of no objection through affidavit affirmed before notary public in favor of the proposed partnership FPS of her mother Nirmala Mandal and sister-in-law Pratima Mandal. Finally, she has submitted application on 28 September 2022, that is after 15 years from the date of death of her father. The applicant could not explain the reason behind inordinate delay in submission of her application. In my considered view, submission of an application for compensation ground as cannot be allowed after so many years. Well, this is the only reason of rejection. I am still completely dependent, my lord. I have no means of subsistence.
Yes.
Therefore, my lord, in view of this, I am only seeking review, and your lordship knows better than me, my lord, what are the grounds of review. There could have been, I am on the limited ground that the relevant provision of law was not placed for lordship at the time of hearing this order. There is, my lord, where we can seek review. From the discovery of new and important matter, he has no discovery new and important or evidence after the exercise of due diligence was not within his knowledge or could not be produced by him at the time of when the degree was passed. It was not placed when the degree was passed. Or order made, or on account of some mistake or error apparent, this is not the case, or for any other sufficient reason. I fall within 2 and 4, my lord.
Okay.
Well, I am only seeking review only to the extent that I am not a fence sitter and my case will be considered by the ultimate authorities investigating. If he is not satisfied, then my lord, I
বলা হয়ে গেছে এবার আমি একটু বলি লর্ডশিপ my lord, if I may my lord come to page 18 of your lordship's order, review of which has been sought for.
Yes.
I just this is my lord, the quoted reasoned order dated 17th of September 2024. The second paragraph, having heard Mr. Learned Counsel for the parties, it appears that the reasoned order dated 17th September 24 has assigned the reason for not considering the consideration of the present petition as follows. Then, on scrutiny of the case records and considering the submission of the applicant in the light of the West Bengal Control 2013, it is found that the erstwhile dealer Vijay Kumar Mondol died on 12th of July 2007. This is very vital. Date of death of the licensee. The applicant Kavita Mondol, married daughter of the deceased dealer did not apply for APS license on compassionate grounds within reasonable time. Then rather, she furnished a declaration of no objection through affidavit affirmed before a notary public in favor of proposed partnership APS for her mother, Nirmala Mondal, and sister-in-law. Malad, pausing her for a moment. First of all, Malad, she has consciously abandoned his known right. Consciously, she has abandoned her known right by filing an affidavit recording no objection. After the death of the original licensee, the widow came. Then the daughter-in-law came. Now this married daughter has come. What is this going on? I don't understand. And Lordship kindly sees, and I repeat, but she has abandoned her known rights consciously. So she cannot now turn back or backtrack in any way. And then the date of death is, well, Lordship, I just said, finally she has submitted application on 28th of September 2022. Death occurs
2007.
And then your Lordship has, after 15 years, but the compassion does not survive after 15 years. The very purpose of compassionate appointment in all spheres of life or every society is the immediate need, financial need to mitigate the hardship on the death of the deceased. Maybe an employee, maybe a dealer, or maybe what or licensee here. Now, the compassion does not survive after 15 years. If the 15 years have gone, the remaining years will also go in that way. And now, Lordship kindly sees, the Lordship has correctly held, I just coming to that. In my considered view, submission of an application for compassionate appointment as APS dealer cannot be allowed after so many years. Conditionalities for grant of APS license on compassionate ground is already set out in the West Bengal Public Disposal Order 2013. Applicant has failed to submit application in due time in compliance with the said control order. In 2003, it was 60 days. In 2030, it is 90 days. And the relevant date is the date of death, 2007. But the law brought about subsequently cannot apply. He cannot take advantage of a law subsequently brought about by the legislator. This is also not possible. Now, Lordship, I just place the applicant has failed. Sorry. In due time in compliance. Moreover, the argument of the dependence substance of the applicant is not tenable as she survived all these years without any earning from the APS of his father. APS license on compassionate ground is the largest offered by the government and cannot be claimed as an inherited right of the family members of a deceased incapacitated dealer. As such, the Eastern Element Srimati Government is by rejected. A well-considered order, that's why your Lordship has quoted here. And then SCFS Chachol is directed to take necessary action for declaration of the resultant APS vacancy arising out of death of Vijay Kumar Mondal, ex-dealer, immediately. Let the copy of the order. Then your Lordship's findings are very vital. On the facts and summary of the case, it appears to me that the dead person is married daughter of the deceased dealer, who not applied for the license on compassionate ground, rather filed no objection. Your Lordship has record is quoted in favor of some other applicants who are the family members. Now, as their application were not materialized, the present petition has applied for the license. In my view, there is a long delay in filing the application for getting compassionate appointment. The status of the present petitioner can be considered to be a fence sitter, rightly observed. What is wrong in it? Who was consciously silent and observing the fate of the litigation. After litigation was over, the petitioner jumped over the spot and applied for the license. In my view, the petitioner, being a fence sitter, cannot apply for a license which he has already denied by declaring no objection through affidavit affirmed before the competent authority. In the writ petition, the petitioner cannot claim equity what she already consciously denied. Your Lordship has also read consciously denied to receive. That's what I said, conscious abandonment of known right. Under the above summons, I find no justification in the petition, then there is so none of the conditions under order 47 is fulfilled. Alien issue has been brought on record for the purpose of review and order. It's well considered. There's no scope for review. There is no scope for review. It should be rejected outright.
My Lord will appreciate, my Lord, this amendment has come pursuant to the order of this Honorable Court. And this Honorable Court directed to bring this amendment, my lord. That is, I am placing that 2017, there was an amendment. And that was, my lord, directed to be amended by this order. My lord, kindly come to paragraph.
1 second, Gautam. This judgment cited by Mr. Agarwal, my lord, the facts are entirely different. The 5 months, here it is 15 years. It is 15, then it is 5 months. That's why the division bench considered a different view. Facts are, there no application at all of the judgment.
My lord, kindly consider this judgment that where the coordinate bench directed that married daughter should be included, and thereafter that application was considered and the license was issued, my lord, by the authority. In my view, the above condition, your lordship, kindly last paragraph, are fulfilled in the instant case, as without the mandatory injunction, the writ petition would become infructuous. Furthermore, the very object of compassionate appointment is frustrated if the benefit is not extended immediately. Accordingly, I direct the state government to grant MR dealership in favor of the petitioner if all other criteria are fulfilled. Now, that license has been issued and that license will confirm. The court directly passed the order that if married daughter has been debarred from getting the license should be issued.
Notification was issued, 2020 notification.
Subsequent law.
Okay, heard.
My lord, one thing more, if you are I'm troubling. In paragraph, in page 12, your lordship find the sub-divisional controller, who is the first authority, he has said that the SCFS chancellor recommended and forwarded the case to the DCFS after conducting an inquiry in the matter. He has inquired into the matter. My lord, page 12, the part of the order, second paragraph.
Yes.
Srimati Kavita Mandal, married daughter of late, have submitted application for appearance in place of deceased father. The SCFS recommended and forwarded the case to the DCFS, conducting an inquiry into the matter. The SCFS, on the basis of inquiry, has mentioned the applicant was wholly dependent on her father at the time of his death. The DCFS forwarded the case to the director. Still, my lord, the directorate only on the ground of delay, it has been rejected. And the delay occurred because of this amendment, my lord.
Okay, very good.
Therefore, my lord, I pray for lordship to review the matter and kindly direct the authority to issue the license as directed by this honorable court by a coordinate bench.
I'm passing the order.
Approbation and deprobation at the same time.
Yes, please.
Blowing
take
hot
down.
and cold.
Can 1 is the review, can 2 is the
condonation of
delay. Can 2 of 2025. This is an application for condonation of delay in connection with review application being can 1 of 2025. Having heard the learned counsel for the petitioner, can 2 of 2025 is hereby allowed and disposed of. The delay in filing condonation, delay in filing the review application is hereby condoned. Full stop. Next para. Can 1 of 2025, this is an application for review, heard the learned counsel for the petitioner, as well as the learned counsel appearing on behalf of the state. Hearing concluded, made CAV.
Hearing.
Just a very small mention with respect to item number 22. Lordship has been pleased, as I've been told by my learned junior, Lordship has been pleased to observe that none appears on behalf of the state. I was arguing before court room number 35, and in any such case where I am appearing as the opposite side, it is my request to all the learned seniors who are appearing on behalf of the petitioners, so they kindly.
Very good, very good.
I can just.
Item number
22.
Item number 22 আপনি নিয়েছেন? হ্যাঁ? State is represented through Mr. Miss Sina. নামটা দিয়ে দেবেন, হ্যাঁ? Okay.
Well, before that, my lord, item number 7, my lord, I'm suffering fever till yesterday.
Why you came today?
Till yesterday I suffered. Today I have come, my lord says, let the matter be taken up on 24th. Mr. Debu Shahara is there, I have taken consent. I have, lordships already heard this matter at length. As your lordships 24th, if possible, my lord.
Item number 7.
Item number 7.
You are for the petitioner.
Petitioner, my lord. 24th and or your lordship's
24th is not possible. 24th is a Thursday. I have group 1 matters.
No, 20, then 25th.
Thursday, Friday, both group 1 matters.
Then 23rd.
No.
23rd.
Carry to them. হবে না 30th আর হবে আর 29 তারিখেও দুটো আছে ভেরি গুড তাহলে দেখুন অগাস্টে 4 তারিখ 5 তারিখ 5 তারিখ দিলাম 5 তারিখ একটা আছে হ্যাঁ 4th of August.
4th of August.
Not before that.
Then 5th August.
5th of August, yes.
5th August.
It can be.
My lord, item number.
On the prayer of the learned counsel for the petitioner, item number 7. The matter be adjourned today, list the matter on 5th of August 2025 at 2 p.m.
My lord, grateful Lord.
Yes, call the list.
My lord, item number 3 to 6. Item number 3 to 6, my lord. Bose Institute.
Yes.
My lord. Mrs. Chandrialam is appearing on behalf of the Union of India. My lord, she will start today, but her husband has been expired last Sunday, my lord. So I am praying.
Who expired?
Miss Chandrialam's husband.
Okay.
My lord, the Bose
3, 4,
Institute,
5 and 6.
3, 4, 5 and 6.
the petitioners have concluded their argument.
I know that. I know entire matter.
My lord, Bose Institute may start because they are at the end of the day they are our employer. Our grievance is against them.
On the other matter.
Other matter,
That is-
Union in India, started. Thereafter,
First Union of India start. Thereafter Bose Institute.
Thereafter.
So same matter maybe. So when can
Kindly fix date 30th July, my lord. Last Sunday, my lord.
then it will appear on August 6th. August 6th,
August 6th.
2 p.m.
My lord, one
Not
more,
only one thing.
the last order, in the last order, it has come down that hearing has been concluded on behalf of the Union of India. Except in Union of India, it will be the petitioners. The order dated
That's wrong.
18.
That is wrong.
দেখি দেখি বলো দি কি ভুলভাল হয়ে গেছে
Item 3 টা দেখি।
Item 3.
Item 3 to 6 3 দিন
See, 4, 5 আমরা দেখিনি সেখানে হতে পারে 3 টা
yes
it will be
only this matter no all matters
I don't we
Probably-
petitioners in 4,
probably
5,
all
6
matters the same order was
maybe
passed.
4, 5, 6 probably your lordship has simply adjourned, if I am not wrong. Subject to correction, I'll just see.
4, 5, 6 এর অর্ডারটা বার কর বা 4 এর বার করে একবার 4 এর অর্ডারটা বার কর
Same order
Same order.
same order okay please take down item number 3 4 5 6 same order হবে separate order ঠিক আছে in order dated 18/6/2025 it has been erroneously mentioned that argument on behalf of Union India has concluded but facts suggest that the Union of India has not started the argument. The petitioner has concluded the argument. Thus, the recording in item in order dated 18/6/2025 regarding conclusion of argument on behalf of Union of India appears to me erroneous and the same be recorded. Full stop. An accommodation is sought for on behalf of Union of India on the ground of bereavement in the family of learned counsel appearing on behalf of Union of India. Concerning the submission, the matter be adjourned today. This is the matter on 6th of August 2025 at 2 p.m. for argument on behalf of Union of India.
Grateful, my lord.
All the matters, same order.
Development.
Yes. Call the list.
My lord, may it please your lordship, it is appearing at my instance. My lord, there is an interim order which has been continuing from 21st of March 2024. Has been extended from time to time. And this is the last order by which it has been extended till today.
What is the matter about?
My lord, it is a challenge against the order of an estate officer under the Public Premises Unauthorized Occupants Act.
Yes.
So, my lord, in a similar, my lord, in another matter, which is recorded in Justice Ghosh's order, my lord, the court held that people who have been even unlawfully in occupation, you have to let them be in occupation and you have to auction it to see the best price which it can be fetched. That, my lord, here we have been found to be the lawful subtenants. Despite that, the estate officer went ahead, despite recording that I am a lawful subtenant, he went ahead and gave an order for eviction. Assailing that, we came up before this court and Justice Ghosh passed that order of stay. My lord, the earlier order, my lord, which they have referred to in that order of Justice Ghosh, my lord, that was challenged before the division bench presided by Justice Orijit Banerjee. It upheld the order. They have challenged it in Supreme Court. And that's why this matter is pending. My lord, if your lordship will kindly extend the interim order for a longer period of time.
Which order you have challenged in Supreme Court?
I am for the port, I am for the port trust, my lord. My lord, similar batch of writ petitions, my lord, 22 in numbers, my lord, were disposed of by, my lord, a single bench, coordinate single bench of this honorable court, my lord, which was preferred in appeal, my lord.
Okay.
The honorable appeal court presided by Justice Boshak, my lord, had, my lord, dismissed the appeal, and thereafter, my lord, the port trust authorities, my lord, went before the Supreme Court, my lord. My lord, the SLPs, my lord, which pertain to the same point of law with regard to the same matter, my lord, is pending for final arguments, my lord. And since, my lord, the same point is to be decided by the Honorable Supreme Court, my lord, the earlier coordinate bench was of the opinion that since the Supreme Court is in session of the same issue in question, let there be an order of status quo till the Supreme Court comes to that finding, and thereafter the matter can be heard before this Honorable Court. Now, today, my learned friend is asking for that order to be extended, my lord. My lord, your lordship will kindly not, my lord, principally record my consent, my lord. I appear for a statutory authority. Your lordship may only, my lord, extend it for a limited period, my lord. And in the meantime, if the SLP is, my lord, decided, we can come forward and, my lordship.
So, in this matter, the merit pertains to the same merit before the honorable.
No, I would disagree here, my lord, because in Supreme Court, they were found to be, my lord, in that matter, which was, this is the matter which is now before the Supreme Court. They were found to be unauthorized occupant. They were staying illegally. Here, I have been found by the estate officer to be a lawful subtenant. This is the difference.
Well, the only point that was decided by, my lord, this honorable court was whether, my lord, a person who is unauthorized as on date is entitled to first right of refusal, my lord. There, my lord, we had contended that if you are unauthorized and if the estate officer finds that you are in unauthorized occupation, then, my lord, you are not entitled to FRR. My lord, the property is put up in auction, they get to match the bid. So that was the point, whether they are entitled to match the bid as first right of refusal, my lord. Here also, my lord, they say that we are willing to match the bid Till that time, allow us to occupy the property.
I understand. I understand. Okay, please take down. This matter appears under the heading of extension of interim order. Stop. Learned counsel for the petitioner submits that the merit of the instant matter has already been decided by a corner bench of this court in other batch of writ petitions against which the protest authority initially preferred a mandamus appeal. Failing thereof, mandamus appeal failed thereof, they approached the Honorable Apex Court. The matter is pending before the Honorable Apex Court. Till pendency of that matter, this court has passed an order of status quo. The order of status quo was lastly extended on 30th of June 2025 and it was extended till today. He prayed for an extension of that order. Learned counsel appearing on behalf of the respondent authority raised strong objection and submits that the merits involved in the instant writ petition are different to that of the merits pending before the Honorable Apex Court. Considering the submission and also considering the order passed by this court, order of status quo passed by this court on the earlier occasion, it appears to me that the present petitioner deserves an order for extension of interim order. Accordingly, the interim order passed by this court on the earlier occasion and extended thereafter till today is further extended till August 28,
could it be for a larger time? Because I don't think in the
kindly-
meantime it would be taken
Lord,
up
I-
before the year. Well, Lord, at least till the
28th of August.
My lord, it's a long time, my lord. My lord, I have to oppose, my lord.
Till 15th of September, my lord. He also knows that
My
it
lord,
won't be taken up before the
My
Supreme
lord,
Court.
if my lord, your lordship understands, my lord, it is pending for final arguments, my lord. It will be disposed of on the day it's taken up, my lord. So, my lord,
Last
August 28
hearing,
is a long-
was my learned friend only informed me. Last hearing was
in February. Yes, my lord, because your lordship knows in Supreme Court, my lord, matters are taken up after a few months, my lord. So, February it will be taken up, my lord. August 20 is sufficient, my lord, for them, my lord.
I want the whether there will be an order of that. That is the only issue.
At least 15th of September, my lord.
My lord, we would be prejudiced, my lord, if it's for a longer period.
So
my
that
lord.
before vacation I might come and just if the
Liberty to mention 15th of September 2025 or until further order, whichever is earlier. What is your liberty to mention?
grateful, my lord.
I'm for the private respondent.
Mr. Huda is there.
Milord.
Where is he? The Bandyopadhyay for the state. Go for the state. Whether Mr. Huda are good in this matter?
Milord.
Whether Mr. Huda argued in this matter?
He argued in this. No, he did not argue.
He did not.
Nobody argued, my lord, just pleading complete, my lord. Exchange, everything exchange, my lord.
Affidavits are being
Everywhere is exchange, my lord.
Supplementary affidavit are all been filed, my lord.
Filed.
If I am not wrong.
So what can be done? No one is there for the petitioner. Dada. Twenty-ninth at 2 p.m.
29 final.
Yes, 29th of July. Please take down.
Since, my lord, pleadings are over, my lord, kindly pose the matter for hearing, my lord.
This is fixed for hearing.
Hearing, my lord.
Yes, specially
Hearing.
fixed matter for
Hearing,
hearing.
my lord. For hearing. 29.
None appears on behalf of the
My lord,
petitioner.
my lord, may I pray kindly, my
State
lord,
as well as the private
first
respondent.
week of August, my lord, kindly, any day.
State as well as the private respondent are represented to learned counsels. Let the matter appear in the list. 6th of August 2025 at 2 p.m.
Gratefully. Great.
6th of August. Call the list.
I'm for the petitioner. ma'am. Not subject matter of challenge in the writ petition is the vacancy notice notified under 2024 control order. Your Lordship passed 4 orders in 4 writ petitions. One of the writ petitions order was challenged before the division bench, and division bench passed in order with the request to Your Lordship to consider the matter at early, if possible, at an early date. But kindly take note of the order, entire order, because some ingredients is there. May I read, my lord? This is the order of the division bench passed by the honorable division bench against the interim order passed by Your Lordship. You also kindly go through the entire order because some observation is there. May I read, my lord?
Yes.
The challenge in the instant appeal by the state is to interim order dated 7th April 2025, passed by a learned single judge of this court in 6 civil writ petitions. The lead one is being WP number so this is the writ petition Sudeep Sarkar. The subject matter of challenge in the writ petition was clause 11 Roman 5 of the West Bengal Targeted Public Distribution System, Maintenance and Control Order 2024. The writ petitioner is aggrieved by the said clause insofar as it imposed as an age restriction on the individuals and partners of the partnership firms from applying for MR dealership FIR shop in the state. The age restriction was that the individuals or partners of the prime applying for such FIR shop should be above 25 years and below 25 years, not below 45 years of age. The learned single judge in a detailed interim order having regard to the decision of the Honorable Supreme Court in Bijmohan Lal versus Union of India and others, Supreme Court cases so and several other decisions passed in interim order directing the state to proceed with the consideration of the application but not to grant the license without the leave of the Honorable Court. The learned single judge prima facie found that the argument of unreasonableness of the restriction to be sustainable. This court has heard the appeal of the state against the order over a period of 2 days. The primary thrust of the argument of the state against the impugned order is that the writ petitioner has failed the writ petition beyond the period of 45 years, within which application of MR dealership were required to be submitted. The writ petitioner has not even chosen to apply for MR dealership. It is therefore argued that the writ petitioner in the instant case was not entitled to any interim order. The interim order does not inure any benefit to the writ petitioner. There is substantial, kindly take note of. There is substance of the argument of the state in this regard. It is well known settled that there is a presumption of constitutionality of the legislation once it is passed by the legislature and assent is given by the governor or president as the case may be. A question could arise in the same principle is applicable to the subordinate legislation and rules framed under the statute. The learned single judge ought to have discussed the above while considering the passing an interim order. The court further notes that in a recent decision of the Honorable Supreme Court in India versus State of Andhra Pradesh and so and so, the test of reasonableness of a restriction under Article 14 of the Constitution has been expanded to include the substantive clarification test. The test has been made more stringent than the pre-existing test. The pre-existing test being existence of intelligentsia, differentia, and national nexus with the object subject to be achieved by the so-and-so, which is now called a substantive clarification test following the principles from the Canadian Constitution. The Honorable Supreme Court of India, in the case of Dr. Rao W. VBT, General case, Supra at paragraph 51 and 64, has observed that the earlier test of reasonableness under Article 14 of the Constitution of India is required to be relooked and reconsidered in the light of the substantial reasonable test. The next page. Additional parameters have been specified by the Honorable Supreme Court of India, that is, as to whether the classification would entirely result in strenuous or some prejudice other similarly placed clauses. Yet another test to be applied to the challenge is the doctrine of proportionality as explained by the Honorable Supreme Court. Judgment has been relied on. Then Mr. Shishana Bandhavata, Learned Counsel, relied on those judgments. Kindly turn the page. Interim order are not granted without exchange of affidavits where constitutional violation of the provisions of the so-and-so. That was the submission on behalf of the state. It is also argued by reference to the aforesaid judgment that their rights under Article 19(1)(g) of the Constitution of India cannot be claimed in respect of a PDA status and subordinate legislature rules. There is substance in the argument of the state in this regard. Per contra, the learned senior counsel, Mr. So-and-so, appearing on behalf of the petitioners, respondent has placed reliance on the decision of the Honorable Supreme Court in India in case of Brojmohanlal so-and-so judgments. Then will kindly come to paragraph 14. It is submitted that in case of Rakesh Vishnava, the Honorable Supreme Court of India has passed an interim order staying the provision of statute even at an ex parte stage. It is now well settled that each case depends on its peculiar facts and circumstances, the circumstances under which the Honorable Supreme Court of India felt the need to stay under the statute also wherein the farm law were under challenge. Public protest Europe lead to a stronghold movement of the persons of people of the so-and-so. Having, kindly take note of this paragraph. Having regard to the aforesaid discussion, this court is of the view that interest of justice would be served if the state is allowed to proceed with the selection process and also issued license for MR dealership and distributorship under the amended targeted public distribution control order of 2024, applying clause 11, there shall however be a rider to each license issued indicating that the same shall abide by the result of the proceedings pending before the learned single judge of this court. The impugn order is modified accordingly. Well, try and take note of. If they issue a license, they have to give a note that this license is subject to the result of the pending petition.
Yes.
Even MR distributor, MR dealer, all. This is judgment in name, not in persona. Dealers and distributors. Kindly take note of. It is made absolutely clear that the court as of now has not disturbed any of the observation of the single bench in the impugn order. According to my understanding of the observation has been accepted by the division bench. The same shall be subject to the arguments advanced by all the parties and the final result of the writ petition. It is expected that all the writ petition on the subject matter in challenge so-and-so, controller so-and-so may be listed together before the learned single judge of this court on an early date after the state file his affidavit within mandatory period of 7 days. Kindly take note of. From date and reply to the so-and-so 3 daes. Well, that has been done. The learned single judge is requested to dispose of the writ petition after hearing all the parties at an early date, subject to its business permitting. It is made clear that this court has not made any final pronouncement in favor of the either of the side into favor of clause 11(5) of the control order of the year 2024 as concerned, and all the questions are deemed to be kept open for decision by the learned single judge and influenced by the observation made by this court in this order. As a matter of amendment caution, the parties shall be in addition to the citing judgments already referred to by the learned single judge and in this order may rely upon any other decision so-and-so with the aforesaid observation the impugn order dated so-and-so Corporation shall be stand modified in view of the so and so. So, my lord, in terms of this order, affidavit has been exchanged. Now matter is ready for hearing. I am filing my reply. Reply to the one. So kindly come to prayer of my writ petition first at page 16. 1-6.
So, which matter? This matter is item number 25.
My lord.
Only 25 or other matter?
25, I shall give the numbers because this matter will not be concluded today.
Yes.
All the matters I have moved, I shall give the numbers.
Yes, all the
All
matters-
issue are same. All the same.
All issue are same.
Same.
There may have some 8 matters or 9 matters like that.
I moved 6 matters.
You have only on 6 matters.
And
But
some
there
matters are pending
other
in the list,
matters
you are
are
not
pending
mentioned.
matters.
Some
So,
matters are
you
pending.
have 6 matters.
6 matters. That has been indicated by the learned single judge.
Yes.
If your lordship deliver a judgment, a single matter, that will cover all. Your lordship kindly take up my lord page 17, page 16 of my repetition. What is my prayer?
Okay. Just. Where is the affidavit by the state?
They have exchanged, my lord. Possibly they, when they will argue, but they will file.
No affidavit.
Because I shall not rely the affidavit from there.
And the affidavit is not on record, my lord.
No.
Kante pathana. Kante pathana. That will be filed on the next day, my lord.
Monday, my lord.
Affidavit not on record. No affidavit in opposition and reply there.
Then kindly takes it on Monday, my lord.
না, না, আমি
File
তো আমরা
everything.
করি, আমি তো এভিডেভিটে কোনো কিছুটা রিলাই করছি না। ওরা যখন বলছি তখন এভিডেভিট দিয়ে মামলা করছি। হ্যাঁ, এভিডেভিট তো আমি রিলাই করছি না। তোরা তো কোনো নতুন ডকুমেন্টসও দিস না। I can serve the court. But today I can hand over my opposition. If everything served upon
You don't have the copy affidavit?
Don't have the copy.
6
Yes,
matters are there. Very good.
My lord, kindly come to page 16.
I'm taking note that they have served affidavit.
Yes,
upon-
absolutely. I can hand over a copy to your lordship.
Just keep it here, sir. Page
16 of my petition prayer.
Yes.
1-6.
Yes.
But one provisions of the new controller Act 2024 and the vacancy notice was under challenge that I want to show before your lordship from page 16. A writ in the nature of mandamus declaring clause 11, Roman 5 of the West Bengal targeted public distribution system, maintenance and control of 2024 as ultra-virus in Article 14, 91G and 21 of the Constitution of India. Pair B. A writ in the nature of mandamus commanding the respondent, each one of them, their servant agents or assigns, to resign, cancel, and or withdraw the vacancy declaration notification bearing memo number so and so issued by the subdivisional control of food and supply so and so. So these are my main prayer. Quashing of a particular provision of the control order and the vacancy notice. It is automatic.
Yes.
Yeah, should be. And the pair C, my lord, kindly read. It is the nature of mandamus commanding the respondent, each one of them, their servant agents or assigns, to declare fresh vacancy. After cancellation of the present vacancy, declare a fresh vacancy so that by kindly read my lord, fresh vacancy of fair price shop at so-and-so, odd number so-and-so, Gangarampur, in the district of Pirouzpur, reeling clause 9(2) of the vacancy declared notice, which restrict me to participate in the selection process. This is the entry point H1. But these are my 3 pairs. Therefore, kindly turn to clause 30C, page 48 of the page 38 of my writ petition.
Yes.
It starts from my lord page 31. West Bengal targeted public distribution system maintenance and control order. If you will kindly come to page 38.
Yes.
Paragraph 13. Clause 13. Paragraph 11. Clause 11. Eligibility criteria for application for grant of license for fair price shop as an individual or a registered partnership firm or a registered cooperative society or a self-help group or a Sangho and Mahasangho of self-help group who fulfills the following eligibility criteria may apply for grant of license for fair price shop on payment of an application fee of ₹1,000, namely the individual applicant or partners of the registered partnership firm or members of the registered cooperative society or members of the self-help group or Sangho, Mahasangho of self-help group applying for a delayed vacancy must be adult Indian citizen. Now, Mala, kindly come to clause 5. 11.5. The individual applicant or partners in the partnership firm must be above 20 years of age. It has been wrongly recorded in the division bench judgment 25 years. The individual applicant or partners in the partnership firm must be above 20 years of age and below 45 years of age on the date of application. Proof showing data birth should be furnished. Now, your lordship, kindly come to page 53.
Yes.
Page 53, clause Roman 6, 39, clause number 39, chapter Roman 6. Provision for grant of license on happening of the certain contingency. Engagement of dealer, distributor on the death of medical incapacitation of a licensee during validity of license. Now, your lordship, kindly take note of this. There is no bar, which I have also submitted at the initial stage of motion stage, that compassionate appointment, there is no bar. A person 90 years of age died, his widow 88 years of age can apply for.
Yes.
Kindly read my lord, subclause 3. The applicant shall, while applying under subclause 1 or 2, have to comply with the provisions of chapter 11 or clause 30, except provision under paragraph Roman 5, clause 11. Kindly take note of. Clause Roman 5, clause 11, paragraph 5 says not above 45 years at the time of entry in the business. So far the general candidate, general vacancy is concerned. So far the compassionate appointment is concerned, it says relaxation. So far this part is concerned. I am repeating my submission that at any age, any person can apply for compassionate appointment. Why I am saying so, my lord, there should be an object. The state framing a policy. There should be an object. There should be an transparency. There should be no discrimination. There should be fairness. If the object is that a person after 45 years is allowed to be entering in the business, it will be difficult for running of the business by the person concerned. If that is the object of the state, then in compassionate ground, the same principle should have been followed. But state cannot create a new class within the class. We all are getting new license. Whether it is compassionate or not, it is immaterial. But a special class has been created by the state in respect of the compassionate appointment by saying, even you can apply at the age of 90 years. So the object to restrict the persons has not been clarified. Why? There is no reason has been disclosed. This is the reason for entry point at the age has been restricted. Again, it will be strengthened my submission also. If I applied for in a dealership at the age of 46 years, 45, 4 years, 11 months, 29 days, I shall be allowed. And I may continue up to 90 years also. If it is the principle or logic or the object of the state is concerned that at age, after a age, you cannot run this type of job, so you are fixing the age. Because there is no retirement. Your Lordship knows in service matter there are restrictions. But at the age of 60, you have to retire. When you are not giving any limit, any ceiling limit, so far the retirement is concerned, whether you can restrict the person at the time of entry point. Because you are not saying in anywhere that after 75 years of age or after 85 years or after 60 years of age, license shall be taken away from you and it may be given to your family members. If you can take an entry, you can continue up to your death, that may be at the age of 90, 95 years even. Now, Your Lordship, kindly take another provisions, clause 39, clause, sorry, my Lord, clause, just I am showing to Your Lordship. Clause, kindly turn to page 48. My Lord, kindly come to clause 30. 30C, small c. At page 48. Eligibility criteria for application for grant of license for distributorship. We are the dealers, before Your Lordship. C, I am reading C. The individual applicant or partners of the registered partnership firm or members of the registered cooperative society, Mahasangha of self-help group must be adult Indian citizens. In case of individual applicant or partners of the partnership firm, the applicant must be above 21 years of age and below 50 years. But what is the reasons? Dealers are dealing with 5,000 ration cards. In their entry point only 45 years. Distributors are dealing with at least 50 dealers, meaning thereby 250,000 ration cards. If we take up, my Lord, average 5,000 cards for every dealer in terms of the circular, then the distributors are dealing with 250,000 ration cards. In their case, entry point restriction is 50 years. More serious job. There are duty to deliver the goods to the door points of the dealers by using their own vehicle. I shall give references of this, my Lord. Huge godown, huge office room, at least 4 or 5 vehicles, not less than 20 employees in the office room, 50 laborers to carry the goods. Dealers' duty is to get the ration articles in the doorstep, distribute the same to the ration card holders by using the e-post machine. A person concerned himself can do it or engaging a single person. So far the distributor is concerned, at least 20 employees are required. At least 50 laborers are required. everything has to be looked into by the distributor. This hazardous job is being done by the distributor. More serious, they can apply entry at 50 years of age. No reason, nothing. This is also another discrimination. I must say, my lord, distributors have also been deprived, rather, my lord, discriminated. But comparison to them, our deprivation is more. The distributors have also filed writ petition that is pending before your lordship. But my submission would be, why this discrimination? Why this difference? When a person is taking more seriousness, doing more serious job, his entry point has been restricted to 50. A more lesser job, in case 45 years. Now I have placed before your lordship, possibly this is in file. 2003 control order. Possibly that is in the file. Or otherwise, I
Yes.
should have not.
Perhaps it is here.
At the initial stage, we have placed it. Yes. Your lordship got it, my lord. But there is a page mark in right hand top in typing. Kindly turn to my lord, page 29. There is a flap also. Your lordship got it. Clause. It starts from my lord, page 28. Paragraph clause 19, Roman 2. Clause 19, Roman 2. May I read my lord? Page 29. Page 29. Top.
Clause
After
19, Roman 2.
my lord. After Roman 4,
Yes.
my lord, first line of clause 19, appointment, issue of license and termination of dealership. Kindly take my lord, Roman 2. Any bona fide citizen of this state may apply for appointment of a dealer in Form A, and after having the application, the Subdivisional Controller, Department of Food and Supplies, shall arrange for an inquiry by the inspection staff attached to the so and so and so. But there is no part, neither in the entry part nor in the 2003 control order. Any person can apply at any age. Any age. Page 1.7. 1.7.
Yes.
Well, kindly take the book. So far, 2013 control order is concerned.
Yes.
Book which is 1.17. 1.17. Clause 20. Engagement of dealer. 1.17 top. Clause 20. Clause 20. Engagement of dealer. In the event of.
Yes.
But the situation when vacancy arises has been given, then kindly take up my lord, Roman 2, obtaining approval. Declaration. Kindly turn to my lord, page 1.19. Following person shall not be eligible to apply for a license of a dealer. But in the previous clauses, there is no bar, no age bar has been restricted, and then these are the bar which has been provided in control order. Kindly read my lord, A, B, C, D, E. It does not say any age.
No age bar.
No age bar. So, my lord, 2003 control order, under 2001 control order, there is no age bar. 2013 state control order, under central control order 2001, there is no age bar. So we can simply say this is a change in the statute. Because I shall rely upon our judgment. There is two things, my lord. First, my lord, you are incorporating a thing, a new thing, without any reason, without any object. The next thing is that till 2024, all persons have been allowed to participate. Now we are changing the law by restricting, imposing a clause whereby you are restricting persons having more than 45 years age to participate in the selection process. So this is a change in the statute.
Yes.
The next submission would be, my lord, these are my facts of the case. My specific case which I have made out in my writ petition, that this creates a restriction which curtail the fundamental right protected under Article 14. Why I am saying 14? You are allowing some persons to make application on compassionate ground even after 80 years. This is discrimination. Clearly hits the Article 14 of Principle of Natural Justice. Equality before the law. You are not treating equally to all persons, all citizens of our state. Directly hits the Article 14 of the Constitution of India. Restriction, class within class.
Yes.
And that too, only in respect of a fresh vacancy. My second point is, my lord, violation of fundamental right, Article 19(1)(g).
Yes.
My lord, right to get a license is not my fundamental right. But right to participate in the selection process, to get a license for livelihood, clearly violates 19(1)(g) of the Constitution of India. You are taking my right while the Parliament or the Constitution never says that after 45 years age, a person will not be become to run any business or service. You are imposing a restriction, violating my right to participate in the selection process, to get a license for my livelihood. This is directly hits 19(1)(g) of the Constitution of India. It also hits, my lords, Article 21. Right to do a lawful business is protected under Article 19(1)(g) of the Constitution of India. You are restricting me to get a license to do the lawful business. It also hits, my lord, Article 21, livelihood, the person concerned. So my conclusion of the submission is that
yes,
the incorporation of the specific clause or change of law is unreasoned, non-speaking, and no object. Unreasoned, non-speaking, and no object. No reason has been disclosed anywhere in the control order that for these reasons, we are restricting the dealers to apply 45 years, and we are restricting the distributors for 50 years. And we are allowing compulsory ground even after 90 years. And a person, if applied on 44 years, 11 years, 11 months, and 29 days, he may continue up to 19 years. These are 4. Discrimination. It is arbitrary, unfair, no justification, unjust. totally discriminatory. Having no object, and particularly this is impractical also. So unseen, non-speaking, arbitrary, unfair, unjust, discriminatory, having no object, and impractical also.
Yes.
But National Food Security Act 2013 and Targeted Public Distribution System 2015, framed by the central government, never imposed any restriction in regard to appointment of dealership so far the age is concerned. My submission would be, this is contrary to the, this is inconsistent also with the 2015 control order. Section 5 of the essential commodities with no uncertain term says, you may frame a rule as a delegate, and in this regard, I am issuing an order specifying the terms and condition, how and which manner you will frame the rule. Accordingly, following Section 5, in exercise of the power, Section 3 of the Essential Commodities Act, central government framed 2015 Targeted Public Distribution Control Order. State government, in exercise of the power under Section 3, read with 2015 frame control order. Accepting that our rule should be consistent with the central control order.
2015.
I'm getting this. 2015 never suggests, not even by the National Food Security Act. The procedure has been laid down in 2015, how and which manner dealer shall be appointed. There is no whisper that at the entry point, you should not allow any person above 45 years to make an application. This is inconsistent to the 2015 central control order also. But this public distribution,
yes,
but this public distribution system and at present targeted public distribution system is not meant for any food officials, it's not meant for dealers, it's not meant for mallet distributors. It meant for mallet consumers,
yes,
poor people of the society. What is the best way to select a best candidate? His godown, his showroom should be in the central point. His education should be above others. He should be moneyed man so that he can invest the money. So best, if you want to choose a best person, then it should be wide enough. A 46 years age person of the central locality having godown come showroom based with money, he is restricted. So best person is not being appointed. Ultimate sufferings by the consumers. To choose the best person to be a dealer in the location, you are not allowing person. In all selection process, Supreme Court time and again says, you have to wide open, you have to publish the advertisement so that more person can participate and best person can be choose. By restricting the person at the age point, you are not taking the benefit of best person of the locality to be appointed as dealer. No, just I'm giving one or two examples. Malad, I have a shopcom go down. Besides the 20 feet roads, 20 feet wide roads, I have money in the bank account. I am a graduate. Another person whose shop farm go down is a remote place within vacancy location. And go down and shop room is much lesser than me. Bank account only 52,000. Room is not ventilated, hygienic also. Both we apply for. Both are 45 below age.
Yes.
Who will be given the license? The person concerned, who is the most suitable, meaning thereby moneyed person, location, everything. But this person is 45 years and old one day. What will be happen? The inferior candidate must be given the appointment. Ultimate sufferings is the consumers. Time and again in the previous part of the National Food Security Act, it has been repeatedly says the targeted public distribution is system is meant for the consumers, not for food officials, not for my clients. You are harassing the persons by giving license to a person whose shop room is situated 2 kilometers far away from the central location, which is situated in a narrow place. There is no scope to park the vehicle to unload the goods from the distributors. You are also draining public money by way of giving carrying charges to the distributors for carrying goods in a distance place.
Yes.
But these are my submissions. I shall rely upon only one judgment. Bar Council of India judgment that I have placed before Lordship. 1995 one is judgment.
You have relied Bridge Mohan.
My lord, 1995 1 SCC page 732. Indian Council of Legal Aid and Advice versus Bar Council of India. But this is the only judgment where entry point and retire point has been considered, and there is no 1995 1 SCC page 732.
1991 on SCC page 732. Indian Council of Legal Aid and Services. Yes, it is.
But before placing the paragraph, this is paragraph 2. I shall read para 8, 12, and 13. But this is the only judgment of the Supreme Court where there is no age limit in the upper age limit. An advocate may practice up to 90 years. But all other judgments in respect of service matters, there are age limit in the retirement. So it says after 60 years, other judgment says you are not capable to do the job. So for this judgment is concerned, which considers that you can continue till your death as an advocate, but you cannot restrict any person in the entry point. Kindly take note. But kindly take up paragraph 8 first. I shall rely upon para 8, 12, 13, 14, and 15. 8, 12, 13, 14, and 15. Page. What page? Hold page. Paragraph 8 at page my lord 740. May I read my lord?
Yes.
The newly added rule seeks to bar the entry of persons who have completed the age of 45 years, same age, on the date of application for enrollment as an advocate from being controlled as such by the State Bar Council concerned. While Section 24 of the Act prescribes the minimum age bar for enrollment as 21 years complete, there is no provision in the Act which can be said to prescribe the maximum age for entry into the profession. Can you take note of? Since the Act is silent on this point, the Bar Council of India was required to resort its rule-making power. The rules made by the Bar Council of India under Section 49, subsection 1 of the Act are in 7 parts, each part having its own chapters. Part Roman 6 is entitled to rules governing advocates, and the said part has 3 chapters. Chapter 1 sets out the restriction on senior advocates and relatability to Section 63 and 49(1)(g) of the Act. Chapter 2 lays down the standards of professional conduct and interpret the relation to the section so and so. I read with proviso there too. And chapter 4 so and so. Then you'll have to kindly read, my lord. This paragraph is that paragraph 12 at page 4743. This is a lengthy paragraph, but I want to read it to your lordship.
Yes.
There is no specific provision in section 7 of the Act which commemorates the functions of the Bar Council of India, empowering it to fix the maximum age bar. Well, so far the 2015 Central Control Order or NAFSA, nothing has been given power to the state, beyond which entry in the profession would be barred. That is why reliance is placed on the rule-making power of the Bar Council of India, enshrined in section 49. The section empowers the making of rule by the Bar Council of India for discharging its function under the Act, and in particular, such rules may be prescribed the class or category of persons entitled to be enrolled as advocates. The function of the Bar Council of India, enumerated in section 7, do not emphasize laying down the stipulation for disqualification persons otherwise qualified from entering the legal profession merely because they have completed the age of 45 years. On the other hand, section 24A was introduced by section 19 of the Act 60 of 1973 with effect from 31st of January 1974 to disqualify certain persons from entering into the legal profession for a limited period. By the impugned rule, every person, even qualified, but who has completed 45 years age, is debarred for all times from enrollment as an advocate. If it had been possible to restrict the entry of the even those class or category of persons referred to in section 24A by a mere rule made by the Bar Council of India, where was the need for a statutory amendment? That is the presumption, because matters concerning disqualification even for a limited period was considered to be falling outside the ken of rule of making power, being a matter of public policy. It is difficult to accept the interpretation that all those above the age group of 45 years constitute a class within the scope of section so and so, permit the Bar Council of India to debar their entry into the profession for all times. In the guise of making a rule, the Bar Council of India is virtually introducing an additional clause in section 24 of the Act prescribing an upper age limit of the completed age of 45 years, beyond which no person shall be eligible for enrollment as an advocate or inserting that additional clause in so and so. Viewed from either point of view, we are clearly of the opinion that the rule-making power under clause AG of the section 49 of the Act does not confer any such power on the Bar Council of India. Pausing for a moment, my case is that 2015 Central Controller never empowers the state government. We are unable to subscribe to the view that all those who have been completed the age of 45 years and are otherwise eligible to be enrolled as advocate constitute a class or category which can be disqualified as a single block from entering the profession. Besides, as stated above, clause AG relates to the definition and specification of a class or category of persons entitled to be enrolled and disentitled to enroll as advocate. We therefore are of the opinion that the impugned rule is beyond the rule-making power of the Bar Council of India and is therefore ultra-virus to the Act. Now you will also kindly take up paragraph 14 and 15, just small paragraph, the operative portion of the judgment. In the view that we take on the aforesaid points, we do not consider it necessary to examine the larger question of whether or not the impugned violates Article 91G of the Constitution. We therefore do not express to answer. In such result, this petition succeeds. The new Rule 9 inserted in clause chapter of the extracted in the reporting particular of this judgment is struck down as ultra-virus that as a applicable of Article 14 of the Constitution of India. The Bar Council of India and the State Bar Council are directed not to implement the said rule, but no other further cost. I think, my lord, this is the only judgment squarely covered by my case. Upper age limit, no age limit. Entry point, age limit. You cannot restrict a person when he fulfill all eligibility criteria only on the count of age. This is Article 14. Supreme Court says. Class within class. And my favorite judgment I have placed before your Lordship, Bridgebone Lal versus Union of India, 2012, Volume 6, Supreme Court cases, page 502. That is also I have given to your Lordship.
Yes.
Can you take note of? Lordship, time and again gone through it. When and state policy can be interfered by the court of law, by the writ court. Bridgebone Lal. 2012, Volume 6, page 502. Everything আমাদের ডিভিশন এর যেটা তুমি লেখ করছো একটা আছে well to got it 100 paragraph 100 and 101 at page 100 and 100 কত যাবে মানে page my lord this no ওটা তো এই page 58 of the online page 58 online 5% ওখানে পড়তে হবে 550 মানে I'm reading a small paragraph 100. Certain tests whether this court should or not interfere in the political decision of the state, as stated in other judgments, can be summed up as in the policy fails to satisfy the test of reasonableness, it would be unconstitutional. The change in policy in our case must be made fairly and should not give the impression that it was so done arbitrarily or in an ulterior intention. The policy can be faulted. The policy can be faulted on grounds of malafide, unreasonableness, arbitrariness, or unfairness. Well, this is my case. If the policy is found to be against the statute or the constitution of, or runs contrary to the philosophy behind these provisions. Well, every point I have argued before your Lordship, squarely covered by all these points. And paragraph 101. Cases of this nature can be classified into two main classes. One class being the matters relating to a general policy decision of the state, and the second relating to fiscal policies of the state. In the former class of cases, the courts have expanded the scope of judicial review when the action are arbitrary, malafide, or contrary to the law on the land, while in the latter class of cases, the scope of such judicial review is far narrower. Nevertheless, unreasonableness, arbitrariness, unfair actions on the policies contrary to the letter, inter and philosophy of law, and policies expanding beyond the permissible limits of delegated power will be instances where the courts will step into the interfere in the so and so. So far fiscal policy, monetary matter is concerned, this is separate policy, but in respect of public policy, that should be followed. So, my lord, I am concluding my submission by saying once again, this clause and relying on clause which has the vacancy has been notified, just your lordship can take note of the vacancy notice. Page 25 of my writ petition. আজকে শেষ করি কপি দিস নি আমার দিচ্ছিস অ্যাপল বলেছে আনছিস But kindly see, this is a vacancy notice of 17 December 2024. This is at Bangarampur, Dakshin Dinajpur. Kindly read the first paragraph, part 1. In cancellation of earlier notice by dated so answer 15th of February 2022. Kindly pause for a moment. So previous vacancy was under 2013 control order. Your lordship knows, my lord, 2024 control order came into force 1st August 2024. At that material point of time, there was no bar when the initial vacancy has been notified. All persons have been allowed. Now, read. Of the Department of Food and Supplies, Government of West Bengal, applications are invited for filling up the vacancy of fair price of dealership under the West Bengal Targeted Public Distribution System Control 2024. So, this is a change. Persons who have applied for in the previous vacancy notice, pursuant to the previous vacancy notice, they have been barred also. This is my case also in the present writ petition. Now, your lordship, kindly come to the next page, the restriction part, eligibility criteria, part 2. page for 26. আরে রাহুলের মুখস্থ আপডেট করে দিয়েছি। Page 26, part 2, eligibility criteria. The applicant must fulfill the following eligibility. Have a look, following criteria. The applicant must be an individual permanently residing in the Ganganapur subdivision. However, reference should be so and so. Then kindly come to Roman 2. After ABCD, 1 ABCD, then Roman 2. The individual applicant or partners of the partnership firm must be above 20 years of age and below 45 years age on the date of application, well, relying on the statutory clause. That just I am concluding my submission. At the mentioning the first submission, so far the division bench judgment. Division bench says none of the findings of the learned single judge interfered with. But this observation has not been challenged by the state. We are modifying the order only on the sole ground. Virus is under challenge. Normally, in case of challenge of virus, this is limited scope to pass interim order. We are remitting back the matter to the learned single judge with the findings. None of the findings as disclosed by the learned single judge not interfered by the division bench. I think, my lord, it is the duty of the state advocates to first prove the observation given by your lordship in the previous order to nullify those findings. These findings still exists. The sentence says, my lord, just one line I am reading from the order. Kindly come to, my lord, page 6, inner page 6 of the order. First, my lord, paragraph 16. Then paragraph 16. Paragraph 16 says there should be a rider in the license, in every license.
Yes.
For distributor and dealer, whether case has been filed or not. Judgment in rem. Paragraph 17. It is made, kindly see, court has taken the where persons who are not coming before the court, even in their cases, in the license, there should be an indication that if the repetition is allowed, license should be cancelled. Then paragraph 17. It is made clear, absolutely clear, not clear, absolutely clear, that this court as of now has not disturbed any of the observation of the single bench in the interim order. The same shall be subject to the final arguments advanced by all the parties and the final result of the repetition.
Honorable Division Bench has noted two judgments.
Yes, all judgments.
Honorable Supreme Court.
Yes.
State of Andhra Pradesh versus Dr. Rao VBT.
That's the state has placed.
Telican.
My lord.
And Rakesh Vaishnav.
Yes, and page 5 that has been placed by the state, and page 5 so far I placed the judgment. I have relied both the judgment before your lordship, but so far the judgment I have placed before the honorable division bench. In regard to interim order, that I am not placing, because this is now your lordship is.
This is a matter of interim order.
Yes, that was in the. That is the case, my lord. Your lordship knows, my lord, in Haryana, Punjab, there was a change of Essential Commodities Act.
Okay, okay.
And huge. So I placed before that judgment that an ex parte interim order has been passed by the honorable Supreme Court. The division bench says that was situation was grave, so Supreme has to. That has been also recorded in paragraph 14.
Yes.
So I am not relying on, because today you are not for interim order.
Okay.
So these are my submissions with the pair A and B, that these provisions of the control order, not the entire control order, must be quashed and set aside. And impugn order automatically will be set aside. And fresh vacancy should be declared, lifting the bar at the entry point. These are my submissions. He is paying for 21st.
No, my lord.
21st at 2.
Purchasing fixed আছে।
কতখানি fixed আছে? 21 তারিখ 10:30।
So where is the AO?
We'll file it shortly, my lord. It is not here, my lord.
Today are you filing
Within
this?
5 to 10 minutes, my lord, we'll file.
Okay.
No. But kindly record, my lord, that I have filed my reply.
Yes.
Oh, they are also filing.
They are also filing.
And your lordship may treat the matter as a hardened part because it was not hardened part at the initial point.
Please take down. So when can we start?
Lord, I'll take instruction, but kindly keep it after a week, my lord.
After a week. That is the request of the division. Request of the division. To the Chintu করবে তো? Chintu করবে না তো?
Instruction এটা।
That is the request of the division bench, my lord. Already 1 month.
We wanted to address on maintainability, my lord, but
How maintainability?
it was kept open, my lord.
No. Read the order. Read the order. Read the order.
Very good. Okay.
On merit.
Done. দেখি।
Next Tuesday. Next Tuesday.
Next week.
এই সাথে হয়ে গেছে দেখ না সাথে হয়নি জান 106 hardened part and kindly fix at 10:30 it would be better possibly for all. May I leave, my lord?
I have fixed all 10:30 matters.
10:30. Second matter. But 23rd this matter was fixed, my lord, initially.
Lord, kindly fix it at 23rd only.
23rd. At 10:30 it was fixed.
Not 10:30, my lord. At 2, my lord.
2.
Not 2, my lord.
Or may I leave, my lord?
Yes. At 2 p.m.
নামটা দিচ্ছে না।
I am taking note of affidavit of service. Okay, I am taking note of affidavit of opposition. Affidavit in opposition, while on behalf of the state is taken on record.
We are filing the affidavit filing.
Affidavit in reply on behalf of the writ petitioner is also taken on record. Full stop. In terms of the direction of the Honorable Division Bench, the argument of the matter is started. Learned counsel for the learned Mr. Devbrata Sahara, learned senior counsel, argued on behalf of the petitioner. Argument on behalf of the petitioner concludes. Let the matter fixed on 23rd of July 2025 at 2 p.m. for argument on behalf of the state authority.
Let the matter be treated as hardened part.
Already. Matter hardened part. ये fix करो. Argument on behalf of the petitioner concludes. করার পরে দেখো matter hardened part. Call the matters.
My lord, I am for the petitioner, my lord. The petitioner is a widow daughter-in-law of one disease MR dealer. No, this is 26. Chintamani Sarkar. No, I don't think so. 26 Chintamani Sarkar, Vastadarpur হচ্ছে এটা কি? 26?
Yes, you proceed.
Yes, this is mine.
My lord, the applicant is a widow daughter-in-law of deceased MR dealer. When the MR dealer was alive, he has applied to transfer his license to his grandson. But as the grandson is under 18, it was not done. And then he has written a letter to controller stating that my kindly transfer my license to my daughter-in-law. But it was not submitted because the MR dealer was heavily ill due to cancer, and within 1 month he died. So after his death, the daughter-in-law has applied. His application, her application was forwarded to deputy director license. Then it was there was no anything happened. Government sat over on the application. Then in 2014, they have issued one notification. The petitioner came before this honorable court. The honorable court directed the controller to consider his application to dispose of her application. The controller, subdivisional controller, conducted inquiry and reject the application, stating that they have not able to submit NOC from all auditions, all family members, and she is daughter-in-law, which is not included in the control order on that very point of time, but within few months it was included. My lord, my humble submission is that in the control order, it was categorically mentioned that NOC is required only from dependent family members, and none of the family member who has not given NOC are dependent family member. As per variation certificate given by the panchayat to subdivisional controller, 4 daughters, both all are married and living separately, and 1 son, he has already died. Out of these 5 daughters, 3 has given NOC, 2 has not given. That too, my humble submission on instruction is that they are not at all dependent family member. And as per direction of this honorable court division bench, it is not required. So what need to do, that division bench are directed that the petitioner need to inform the controller address of the person who has not submitted NOC. The controller will notice them whether they are dependent or not. If they are not turned up, then license may be given to the petitioner.
What do you challenge here?
Now my humble submission is I am challenging the order of the this is by my lord 162, page 162, order by subdivisional controller.
Rejection of this.
162. Observation and decision, my lord. 4 and 5. May I read, my lord?
Non-compliance of the West Bengal public decision. Last 2 lines, my lord.
Yes.
Both applicants fail to meet the mandatory requirement of furnishing no objection affidavit from the other legal heirs. Chintamani Sarkar is a daughter-in-law of the predeceased son named Jagannath Sarkar, who died on 5th July 2013 of the late FPS dealer Brajamohan Sarkar. On the other hand, at the time of demise of the FPS dealer named late Brajamohan Sarkar, Jababala Sarkar daughter was married. So the decision was, in the light of the above fact and non-compliance of WBPDS Maintenance and Control Order 2013, Srimati Chintamani Sarkar's and Srimati Jababala Sarkar's application hereby rejected. So, my lord, my humble submission is that NOC from other 2 legal heirs is not required, as they are not dependent on the MR dealer when he was died. And on the other hand, my lord, as she is a daughter-in-law. So a coordinate branch of this honorable court has already decided the issue in WPA 10630 of 2023, Muhammad Arab versus State of West Bengal and others, where the applicant was grandson. The license was in the name of her grandmother.
So what is your submission?
My
At the time of date, who are the dependent?
At that, my lord, it was mentioned in that Warrison certificate inquiry report by Pradhan, page number 117. Page number 117, my lord. Shanto Dev Sharma, Shanti Horijan, Anita Sarkar, Kamala Sarkar, Jababala Sarkar, and late Brajamon Sarkar are his legal heirs. And legal heirs of late Jagannath Sarkar is Chintamani Sarkar, Ujjwal Sarkar, and Pradip Sarkar.
So where is the evidence? At the time of death, these persons were dependent.
My lord, kindly see, my lord, page page 34, my lord. The petition of the deceased MR dealer. 34, my lord. My lord, বিনীত নিবেদন এই যে আমি ব্রজমোহন সরকার MR ডিলার দোকান নম্বর 22/22 ধামদোল থানা ইটাহার জেলা উত্তর দিনাজপুর আমার বিবরণ এই যে আমার 5 মেয়ে শান্ত শান্তি কমলা জবা তারা সকলেই বিবাহিত এবং এলাকা বহির্ভূত।
It is a statement of a dead person. How can it be considered?
No, my lord, then my lord, you can do one thing, my lord. You can direct the controller to reconsider on the light of the division bench judgment. Let them notice and verify whether they are dependent or not.
Then why you not place the materials before the subdivisional controller that these are the persons, I am the person on dependent.
The petitioner was not aware that on that ground.
You never aware. This is the third time you are appearing before this court.
No, second time, my lord. Second time, my lord.
Jawabala Sarkar was also there.
Jawabala Sarkar was also there, but Jawabala Sarkar.
He said against you.
No, Jawabala Sarkar has also applied.
Jawabala Sarkar said he is the dependent. He was dependent. She was dependent at the time of.
No.
Yes, he is also there.
My lord, one more thing, my lord. If Jawabala Sarkar was dependent, then
a party, my lord.
Then, my lord, the disease.
Jawabala Sarkar also placed a writ petition.
A separate petition.
He has also filed a separate writ petition.
Separate petition.
My lord,
that you are not the person dependent. At
no. Then, my lord, kindly see page number 87 and 91. The petitioner, the disease MR dealer, has gifted his entire property. Entire property means only the land to his grandson and daughter-in-law. If that Jawabala Sarkar was dependent on her father, then definitely on her father has done some arrangement for her also.
That is the argument you are making. This is the annotation you are making like that.
No.
On the basis of a deed. Is there written there they were the dependent on me?
Yes.
Is there written in the deed?
Yes.
These persons are dependent upon me.
Yes.
Where it is written?
Yes.
But they are dependent on me.
Yes. Page number 87.
Read. Is there any?
Not 87, my lord. It's 139, and
you read the provision. You read the sentence that these persons whom I gifted the property, they are the dependent.
Page number 121. আমি অত্র দানপত্র দ্বারা প্রচার ও প্রকাশ করিতেছি যে দান গ্রহীতাদ্বয় সম্পর্কে আমার ঔরসজাত পুত্রের ঔরসজাত পুত্র অর্থাৎ নাতি হইতেছে তোমরা আমাকে ভক্তি শ্রদ্ধা সেবা যত্ন সর্বপ্রকারে সহায়তা করিয়া আসিতেছ।
That means the deceased was dependent upon them.
No, then, my lord, it was category. Let me.
Okay, let me call a report from the state.
Yes.
My lord was previously was pleased to direct and file a report, my lord. So kindly extend 2 weeks time, Lord. So
Yes, I directed to submit a report. Where is it? Why you are going so long? You have already argued.
My lord, they have only 700 ration card, and as the dealership was tagged with the nearby dealer, they are.
My lord, I have not a chance to address the word, my lord.
I think it is the
My lord, I am saying the urgency, my lord. The dealership has
There is
only
an interim
700
order, my
card.
lord. There is an
That's right,
interim
that's
order, my lord.
interim
Yes,
stage
there's
has
an
already
interim
been over. You cannot have an interim order now. An affidavit in opposition has been directed upon the state. So where is the affidavit?
Lord, sir, Malik, keep 2 weeks time, Lord, so I'll come.
Again 2 weeks time. Order was passed earlier on. 22nd of April is the order.
Yes, my lord.
Now we are July. That's
At
why
least 10
Learned
days, my lord.
Council is
Kindly-
regarding to dispose of the matter today.
My lord, the urgency is, my lord.
There is
The
no order.
dealership has only 700 card, and
Now the issue is otherwise.
No.
Jawabala Sarkar has also filed a writ petition.
I know, my lord.
Then
but she has no ground, my lord.
Whatever may be the impugn order,
my lord,
impugn order which you challenge has rejected both Jawabala Sarkar and you.
Yes, my lord.
That is the
Jawabala Sarkar is not challenging that. We are challenging that.
Jawabala Sarkar also challenged this order.
This order.
Yes, and separate writ petition.
We are not aware, my lord.
I understand you have not aware. You are not aware.
My lord, then both the petition you can send it to the divisional controller with direction.
Let me take a report from the state.
Lord, so I'll come.
Place the report within 29th.
29,
my lord,
Learned counsel appearing on behalf, Mr. Chatterjee, learned counsel appearing on behalf of the state respondent seeks accommodation for extension of time to file a report. Let the report be placed peremptorily on 29th of July 2025. Exception thereby. No. What is that? Let the matter appear on the agenda. 29th.
Grateful, my lord.
Next.
Lordship, I'm for the petitioner. I'm led by Advocate Shobushai Chatterjee. Lordship is currently engaged in another court. Until he comes, I will assist your Lordship in the matter, if your Lordship permits. Lordship, on last occasion, your Lordship had granted liberty to add the private respondent number 9. We have added the private respondent number 9 and have done the affidavit of service. Your Lordship, in a nutshell, the case is that the petitioner challenges the action of the state respondent for granting the FPS dealership to the private respondent who has failed to satisfy the required criteria. If your Lordship,
What required criteria?
yes, your Lordship, I'm showing your Lordship. If your Lordship kindly comes to page number 26.
Who is for respondent number 9?
Your Lordship, I have the affidavit of
Mr.
service.
Huda, you are for respondent number 9 in this matter? Yes, you are respondent number 9 in the last occasion.
Lordship, the affidavit of
This is in the
service.
matter of Abdul Mannan.
Yes, I'm there. But that is 28, I guess.
27, 28.
27, 28. And my clerk has written 28, 29. So
yes.
If your Lordship kindly comes to page number 26, your Lordship, that is the notification issued by the Department of Food and Supplies for inviting license against the vacancy of fair price shop. Your Lordship, on page 27 in part 4, point 10, subpoint 7, that is documents related with go down and shop office. Your Lordship, there are two clauses, A and B. There, your Lordship may see that document showing character of land as Dukan, commercial or Bastu. This is an essential criteria for the go down to be constructed. Your Lordship, this is an important point which will come into play later. Your Lordship subsequently have applied via this notification along with 10 other applicants, including the private respondent. And Your Lordship, a hearing was conducted on 12/2/2025, and thereafter an inspection was also done. And thereafter, in the official website of the state respondents, it was uploaded that the Asamuddin was granted the FPS license. Your Lordship, it is annexed in page number 67, the screenshot where it is shown that the private respondent has got the FPS dealership. Your Lordship, now my case is that the said Asamuddin has against a plot of land has applied for the tender. Your Lordship, he has constructed the godown not in that plot of land, but in a adjacent plot of land, which is not categorized as commercial or godam.
What is the plot number?
Your Lordship, one second, Your Lordship. Your Lordship,
Before, my lord, this is taken further, my lord. The private respondent, my lord, has obtained the license, my lord. He has been distributing, my lord, food grains for the last, I believe, 3 months, my lord, or maybe more than that, my lord. Your Lordship, a question of, my lord, any interim orders at this stage, my lord?
Your Lordship, the private respondent has constructed his land on a Dag number 3213, which is classified as V2, whereas he has applied for the said FPS dealership against a Khatian number 4719, which is classified as Godam. Your Lordship, the godown is not constructed on that Khatian number 4719. Instead, it is constructed on an adjacent plot of land bearing Khatian number 131, Dag number 3213. Your Lordship, it is written in the para 10 of the writ petition. Explain the fact in detail.
Sir, I shall file, my lord, my affidavit, my lord, showing, my lord, the actual nature, my lord, where's the godown situated with all the details, my lord.
Yes, Your Lordship, affidavit has to be filed.
Yes, yes.
To file affidavit then.
Yes, yes. Okay.
Who is for the state? Sonal Sinha.
Yes, my lord. Miss Sinha was appearing. I think that's
the name.
Lordship, kindly pass the order to exchange of the affidavit. This matter cannot be decided without exchange of affidavits.
That strategy is right.
Okay, please take down. Having heard the learned counsel for the parties, it appears that the incident matter cannot be disposed of without giving the parties an opportunity of the parties to file affidavit, respective affidavit in opposition. Respective affidavits. Full stop. Let the affidavit in opposition be filed by the state authority within 3 weeks from date. State authority and the private respondent within 3 weeks from the date. Reply by the petitioner. Reply stroke exception by the petitioner within 2 weeks thereafter. Let the matter appear in the list on 25th of August 2025 under the same heading.
She has fixed a date after exchange of affidavits. The next matter is also the same, my lord. It cannot be decided without exchange of affidavits, subject to correction of my lord. Mr. Singh.
He will allow it.
Unless he takes up the point.
Next matter.
My lord, I am for the petitioner, my lord. In 28 also, I have a factual point that petitioner has cited the godown. He has cited the residential address as the godown. That is the allegation. And that has been complied with. The private respondent.
You are there for the state respondent. Who is for the your private respondent?
The affidavit may be exchanged and then.
May I just indicate one thing?
But
You have stated that the private respondent has scored 81 marks and the petitioner has got only 71 marks.
Only he basically placed third, not even the second. Now the point of challenge before your lordship that there is no reason has been assigned for rejection of his claim. Now, if I could show from the record, it is not even necessary. Then the matter could have been ends up here. Now, the vacancy notification once, kindly take trouble to see page 34. I will take just 2-3 minutes.
Yes.
Kindly come to page 34. Part 5, Roman 5.
Right to reject.
Right. Fair play in the giant. I have the authority, tender calling authority. I have, without assigning any reason, I have a right to reject, and he has, knowing fully well, participated on the same. Now, after being unsuccessful, he cannot take the point that without assigning any reason, this order has been passed, and I have awarded the same to the private respondent.
With
Just a moment. I have not finished.
No, I didn't say anything, sir.
This is which point?
Yes, Mr. Sengul, to proceed.
Well, possibly nowadays, when I came over here, we have learned the maintainability of the writ petition has to be heard first, then the writ has to be heard in the merit. Now there are certain changes of the profession. I have seen the new bloods have came. Now they have come up with the same things, that writ could have a right to get into the point of the evidence even whenever I am appearing as a petitioner. That is falling from Mr. Chatterjee. Without knowing that there is a judgment of this court, the writ court cannot go into the evidence. Reappreciation of the evidence is not permissible. Now, first he has to apprise the court and to satisfy on the point that he has a good locus to maintain the writ petition.
That means petitioner has to show something really,
prima facie,
really arbitrariness, really
malafidness
of the action of the authority, so that the
judicial intervention can be appreciated. This is what I have learned. Now, since the practice has been developed after Mr. Chatterjee has joined, I have seen this has been become redundant. The point of maintainability has been redundant. Whenever is happening, I am coming over here, I want to order. The rule is that you first satisfy the court. So the point of approbate and reprobate is also coming. You cannot play hot and cold at the same times. You have participated in the tender, knowing fully well what is the condition over here. Being unsuccessful, you coming over here and seeking the relief. This notification was not under challenge. Had it been a case, this he come up with the challenging the notification, this could have been the different dimension altogether. Being unsuccessful is taking a chance. I need not to repeat the judgment of the Tata Cellular, I believe. I need not to. This is the fair play in the giant. I am the tender calling authority. I have a right to reject at any point of time, at any manner. I can reject the vacancy even. I can cancel the vacancy even. First of all, Lordship knows another point. It is fallen from your Lordship initially that there are 5 to 7 people are participating. Everyone I have recommended eligible. Why so? I just clarify this position. This is a technical part.
Yes.
Technical part, everybody can be eligible or cannot be. First, the eligibility criteria of the technicality has to be taken into the consideration. Then, amongst the eligibility criteria, the suitable candidate would be chosen.
Suitable candidate chosen.
Right. Best suitable candidate to be chosen. That is what we have done. The entire procedure has been laid down in the notifications. This notification has not challenged. This point has to be apprised first. Then I will go to the how the conduct that otherwise has been happened, or at all any malafidness or arbitrariness has been caused on. That's all.
So you are challenging the maintainability of the writ petition.
Naturally, my lord. And of course, Mr. Huda's client is running the business. We have granted.
That is the fact. That is the fact.
Right.
But in fact, I would also urge on the point of maintainability. I'm a bit handicapped today. First, we must
keep it open, Lordship. I will keep it open.
But you keeps it any day, Lord.
On this point, approbate, reprobate, everything.
Lordship fixes it any day. Can you fix on Monday? This Monday? Oh, Monday. Monday.
Please take down. Mr. Suman Sengupta, learned counsel appearing on behalf of the state, raised the point of maintainability. He argued that the petitioner herein is an unsuccessful candidate who scored only 71 marks. Post a private respondent has scored 81 marks, and being most suitable candidate, he has been granted license, and now he is running the business. Full stop. Mr. Sengupta argued that being an unsuccessful candidate, the petitioner has no right to challenge the selection of private respondent. He further submits that in terms of the vacancy notification, the concerned authority has every opportunity to reject any application, that too the unsuccessful candidate. There is no reasons to disclose the any arbitrariness or malafide on behalf of the state respondent authority. Thus, the instant writ petition is not at all maintainable. Full stop. Private Mr. Hudar, appearing on behalf of the private respondent, also raised point of maintainability and seeks liberty to argue on that point. Seeks accommodation to argue on the point. Full stop. Having heard the learned counsels, it appears that before entering into the merit of this matter, the point of maintainability has to be heard first. Let the matter appear in the list on 22nd of July 2025 under the same heading.
Okay. Grateful, man. 12 July. What set up of instead of 12 July,
22nd. Next. हम किसी वीडियो चेक दाओ तो हो जाए ठीक है ना
Yes, my lord, I beg to appear for
yes, my lord, I beg to appear on behalf of the petitioner, my lord. Last on 11th July, my lord was kind enough to direct the authorities to file an affidavit indicating the current status regarding the vacancy, whether it is available or not.
Just report.
Reports. Attender my uncle, report.
Yes.
My lord, the candidature of the writ petitioner was rejected on the for non-fulfillment of Rule 8 Roman 5, which says, my lord, that on the date of inquiry, one must show that he has a ready go down, which, my lord, had shown that it was not ready. Now, your lordship was pleased to direct me to, my lord, produce records of file a report, my lord, in respect of the present status of the other applications, my lord. May I just hand over the report and the website status report?
To serve the copy upon them.
Yes,
also.
yes, certainly, my lord. Copy them. My lord, one was found eligible, my lord, and thereafter, my lord, his case was, my lord, forwarded to the department, and the same is now pending, my lord, out of total 9 applicants.
My lord, subject to your lordship's kind sanction, my lord, may I submit one thing?
Yes.
My lord, the issue, what I believe, that one Bhim Pramanik has been chosen as suitable. My lord, let them file a report that Bhim Pramanik, my lord, whether he has established the thing that he is having the finished go down, because I have the photographs of 9 applicants that they are having only kacha structure, not the pakka structure. Let them come with an affidavit to that effect.
There is no such pleading. Secondly, my lord, my learned friend cannot, my lord, request this court, my lord, for a roving inquiry. My lord,
No,
it
no,
is
I
his
cannot.
as to
I am not saying
burden
that.
is on
Once
him.
it has come
Now
before
he
this
cannot,
court,
my lord, put the burden on the authority by saying that we should produce all these things to him.
yeah, exactly,
He
because
was
they
an
are the authority.
unsuccessful
They
candidate.
are
He failed
maybe.
to, my lord, fulfill the relevant provisions of the law, and then, my lord, when the case of a particular applicant has been recorded, and he is not a party to this proceeding, his case has been
I shall
recorded.
imply.
Now it is
Just now it
pending
has
before the
come before
department.
this court that he is the necessary party. Now I will add him under order 1 rule 10.
Should not be go on and on, my lord, for this gives
Absolutely.
rise to a fresh cause of action.
But they cannot choose their blue-eyed boys.
No,
There
Mr.
is no-
Banerjee, the issue is that the fact suggests that your client don't have the proper go down at the date when the inspection was made.
Absolutely, my lord. My case was that through WhatsApp, a document has been furnished to me, indicating that there will be an inspection. I have allowed them. There is no doubt about it. But I have questioned the memo which has been sent by the through WhatsApp, because there was a memo. Kindly see the signature, the date, and the memo issuing authority, whether it is legally valid or not. Whether it can be done by way of a WhatsApp. It has to be done through speed post.
My lord, your lordship, kindly consider the memo dated 5th June 2024, which I was handed over, my lord, on the last occasion, my lord. This is there are some pictures and, my lord, a notification. It will start from this page, and, my lord, this is the notification. The 5th June 2024 notification, my lord. Or I will hand over another one, my lord. It is there. It is there. My lord, may I just handing over, my lord, another copy, my lord?
Notifications?
That notification, my lord. Kindly look at this notification, my lord. 5th June 2024.
Yes, got it.
Yes, my lord. My lord, kindly, my lord, consider the next page, part 2. My lord, part 2, clause 8 deals with eligibility criteria. Then Roman 5, my lord. Kindly consider Roman 5, my lord. The applicant applying against a vacancy of fair price shop must have a ready go down. Yes, ready go down, my lord. As per the above norms on the date of inspection. However, if the go down is otherwise ready, following deviations or exceptions at the time of inspection may be ignored. Now, what are those deviations? If the structure of floor, wall, and roof of the proposed go down is complete and floor is otherwise ready, but tiles or cement furnishing is not done, or if the bitumen coating is not done in case of roof covered with asbestos sheet tin, then go down will be treated as incomplete, but application would be processed. In such case, the minimum marks would be given for such go down. Now, kindly consider these pictures, my lord. I think this is my lord, annexed to these documents, my lord. Kindly see whether this fulfills this Roman 5 or not. The floor, my lord. Kindly see the condition of the floor, my lord. Therefore, my lord, when
Whether
this
there was, my lord, my learned friend is putting certain questions, whether there was any admission with regard to that, because I have submitted before the court that when it was inspected, it was not fully ready. That was my submission and admission in the writ application. Completely, I cannot defy the situation, but the issue remains. I have questioned two things. That number one, whether the official intimation can be sent through WhatsApp. Number one, because page 15, if your lordship kindly sees the page 15 of the writ petition.
No, he attended. Now, how can he, my lord, raise this question? He attended
No,
on the
what
date
I
of
have, what I can, whether I have denied it, I did not deny it in the writ petition. I have submitted, even then I have appeared. Subsequently, I have made the representation before the authority. Admittedly, there was ongoing process. The building was not completed. I have admitted.
My
But
lord, my
now the
specific instruction is, my lord, that petitioner refused to accept the inspection notice, the inquiry notice. Then it was sent through WhatsApp. I can, my lord, put it on affidavit.
My lord, there must, yes.
Only this is the issue.
Very well, my
Yes,
Only
my
this
lord.
is the issue.
My
Very
lord. My lord.
Report, status report filed on behalf of the state authority disclosed that one person, namely, what is the name?
My lord, Bhim Pramanik. My lord.
Bhim Pramanik.
No, Bhim Pramanik now. But this is but Sanjay Sarsoto Rajok is the petitioner.
No.
Now, who is
No.
the selected
The person who was selected.
Forget about the name. Forget the column. Disclose that one applicant was selected by the authority to be most suitable candidate in respect of the vacancy notification, and the same had been sent to the department along with the recommendation through online portal. Full stop. Next paragraph. The issue involved in the writ petition is the petitioner challenged the act and action of the respondent authority regarding issuance of a notice through WhatsApp regarding inquiry of proposed shop come go down of the petitioner. It is the contention of the petitioner that the respondent authority did not issue any proper letter or memo to the petitioner regarding the inspection, but they issued only a WhatsApp message, which is illegal. Full stop. Due to such prompt action of the authority, petitioner are good, the petitioner could not complete proposed shop come go down, thus he became uneligible. Full stop. This being the sole issue, the state respondent is directed to submit a report on the point whether the notice was served upon the petitioner through WhatsApp or whether any earlier notice was sent to the petitioner with proper communication. Let the matter appear in the list next week.
Next week.
My lord.
May I just point out one thing, my lord? Just, my lord, if your lordship kindly consider paragraph 3, page 4, the petitioner, my lord, admitted that he received that notice. Kindly consider 2 lines, my lord.
Received the notice of the
My lord,
WhatsApp.
through WhatsApp.
Yes,
And that is an admitted
exactly.
position. Admitted
No,
because
I have
in fact,
indicated that.
They argued that it is the case of the petitioner that you have not made proper communication.
My lord,
but only send a WhatsApp.
My lord,
Whether
then
this
how, my lord, I
number is
tried,
the official number
how I tried to
of
serve
the
this,
authority.
Yes, you
that I
place
shall
on- you
indicate.
place
my
on
lord.
record.
Very well. Very
You place on
My
record.
lord.
very well,
This is
very
only
My
my,
lord.
Yes, that is the issue. Yes, very
that is the only issue, no?
Yes,
This
my
is-
my
Otherwise,
On
he
24
admitted that on the day of
He was
inspection, it was not complete due
Yes.
to your prompt action.
my lord.
This is the only allegation against the
Next
authority.
week,
Let the
On
matter appear in
24?
the list on 29th.
29. Very well.
My lord, I'm grateful.
So, you should- Take. Grateful, man.
Next.
I appear for the state lordship.
My lord, in this matter, I am appearing for the petition led by Mr. Lahiri, my lord. My lord, I am praying for not today, my lord. Mr. Lahiri has some difficulty, my lord.
Lordship, if Lordship would kindly see the order that Lordship had passed on the 7th of May. Then petitioner seeks an accommodation, stands adjourned, and we had already submitted the report. This is just nothing but a tactic to delay the court, Lordship. Kindly come to 7th order.
You are the private respondent.
Only not today, my lord. He has some difficulty today. That is why, my lord, he requested me.
Lahiri was there, I think,
My
in
lord,
the second half.
my lord, just now he requested me to, my lord, accommodation for the day, my lord. He has some difficulty, my lord.
I have used a particular plot of land. There is no shop come down. The state says this is not the plot of land. These are the plot of land which has been mentioned in the application, which has been mentioned during the course of inquiry, and we have inspected the same. We have granted the license particular part of
State have the report.
We have already submitted the report. It's in your,
Submitted the report.
yes, it's in the record of lordship's
We have
record.
already the exception of the report, my
10 and 11 of the restriction. Only point. For this candidature is
Mr. Laird is there.
Exception apni deben?
No, where is the report? No, no report. is there.
No, we did submit. Anyway, lordship, I can submit again.
You submit, then serve a copy to them.
Because lordship, if
we will submit the exception today and it fixes another day.
Okay. No, I don't have
and on
the-
7th lordship, it's
Where is
recorded
the
in the
report?
order, lordship.
Give me the report.
I'm giving the report, but it's recorded in the order that we had already submitted. So,
Is it?
yes, on 7th. Learned counsel appearing on behalf of the state respondent
Right.
submit that the detailed report has already been placed on record and the instant writ petition is not required to be entertained.
Okay. So you are today filing exception.
Yes, we are filing.
Exception file on behalf of the petitioner
Exception?
against the report.
Thank
Exception file on behalf of the petitioner against the report filed by the state be taken on record. Let the matter appear on 22. 20.
22nd.
I have handed over the copy of the exceptions to the
Yes.
respondents.
কি বললাম বলো? Exception copy served.
Lordship, one small prayer, Lordship. 22nd is just in case we need to give an objection or reply or response, and a couple of more days because I have to get instructions from the department.
next week.
Maybe instead of 22nd, maybe the week thereafter.
Then very well come on 29th.
Grateful, Lordship.
29th.
29th is
29th.
grateful.
Copy served করে দেবে।
Item number 31, my lord. I am for the state, my lord. The correction, my lord. According to 2nd July, আমি স্টেটের হয়ে গেল।
মানে this matter as
কারেকশনটা মানে এটা স্টেটের নাম ভুল আছে। According to this order, my lord, 2nd July, the state petitioner, state advocate's name was changed, my lord. My learned senior Rajasri Basu and me also, but name was other.
Give me your names.
Yes, my lord.
Give me names only.
Okay. Sorry.
কি নামটা আছে দেখে নিন।
Rajasri Basu and
Please take down.
Sanjita Dey.
This matter appears under the heading correction. In the order dated 2nd of July 2025, the representation on behalf of the state by the learned counsel has been erroneously written as Mr. Shopon Kumar Dotto, learned advocate. Learned senior advocate. Learned senior advocate. The representation on behalf of the state was made on that date by name Rajasri
Basu, my lord, and
Mr. Rajasri Basu with
Sanjoita Dey.
Sanchoita Dey. Let the same be corrected by the department within a fortnight. Full stop. Let the matter go out of the list. Parties at liberty to make some. আর কিছু লিখতে হবে না। Disposed of. আগেও disposed of হয়ে গেছে। আর কিছু লিখতে হবে। Next.
Appear for the state lordship.
Lordship, the last occasion, I am appearing for the petition. Lordship, the last occasion, I asked to seek the opinion of my client, my lord. So I have collected a copy of the certified by the local surveyor, my lord, and this shows the actual status of the building, my lord, where the godown should have been created. This is the picture shows, and it totally matches with the criteria of the advertisement, my lord, and there is appears some sorts of misconception somehow, my lord. For lordship's attention, I'm just submitting this, my lord.
Lordship, we have not been served with this, so we really cannot respond to that.
I've served the
What
copy.
is this, Lordship? I really don't understand. I mean, what kind of document is this? If he could just explain from whom, where.
This is signed copy, my lord.
I don't know. We'll have to see.
This is already clear structure, my lord. There is no question of any sorts of deviation. This stands now, my lord. Any sorts of local survey may be made, my lord. I have got it surveyed from the registered surveyor, my lord. My only submission, it differs from the submission of the state and what inquiry they have made. I don't know who is the person concerned who has made the inquiry at the local level, but this is the surveyed report, my lord. And there is, since it is a double-storied building, there is no scope of any deviation. This stands now, my lord. And if it stands,
So what is the issue here?
my lord,
That the state authority has said that your shop-cum go down is not within the locality.
No, no, no. It is all about, we had already, do you have an extra copy? Lordship has a report that he had submitted where the findings of the inquiry officer, along with the remarks of the SCF&S, along with marks and everything. It's a comparison chart, literally a comparison chart, where it is all about the area of the go down. We are not saying that it doesn't exist.
Okay, area of the
go down. We are not saying it doesn't. We are only saying
is 207 square feet only.
yes. Whereas the respondent number 7 who got the license, Babusha Das, the measurement of the go down office is 349.18 square feet. Okay. And the minimum remarks following are the observations. Lordship may just, beside the petitioners, the findings of the inquiry officer, beside that, there are the remarks. Following are the observations regarding ineligibility of the applicant. Minimum required go down specifications are not matched. Because the minimum required space was 100 square feet, whereas his is 76.70 square feet.
Size of the go down does not satisfy the geo. This is the only issue.
Also minor name mismatch.
Name mismatch with RO.
Between ROR and the applicant name. No supporting affidavit produced.
So what is your contention?
My only submission, my lord, this is the already permanent structure, double-storied building. There is no scope of any deviation. I am just giving lordship's attention. This is the structure that stands now. This has been certified by the local surveyor, who is the authorized.
What it says.
My area remains to the go down 318.5 square feet. And the other space where the shop should run, that stands at 120 square feet. As per requirement is 300 square feet plus 100 square feet. In both the areas, my lord, it covers. Naturally, my lord, what they have found out and what exists now, there are two contradictions. My only submission, my lord, this is the survey report I have collected. I beg to submit this report, my lord, and this is the full structure. Let it be seen, my lord, and let them to show that this is any deviation herein. Otherwise, how they could calculate the thing? Who was the expert body in the inspecting the? I think, my lord,
you submit a affidavit. Not by that, you cannot place the document like that. You place with affidavit, supplementary affidavit, if you want to place.
Because, sorry to interrupt, Lordship, but our inspection report, which we had handed over in the last occasion to the petitioner as well as to Lordship, it clearly explains length, breadth, height, everything. So if he is disputing that, then actually he has to come up with an affidavit.
Otherwise,
yes.
Then, my lord,
yes.
then, my lord,
disputing the entire fact.
Then, my lord, I may kindly be allowed to come with the exceptions, my lord, in my affidavit, my lord.
Have you got the copy of the report?
Yes, my lord.
Then you file the exception.
Yes, my lord. And bringing this measurement to your lordship's attention. May I submit one copy, my lord?
No.
Yes, my lord. ठीक है, भेज भेज दो.
Learned counsel for the petitioner intends to use exception against the report filed by the state. Let the exception be filed within 2 weeks. List the matter on 4th of August under the same heading.
Status quo by this time may kindly be maintained, my lord.
No.
Otherwise, we may remain in very adverse position, my lord.
I am objecting to that, Prayer Lordship.
No status quo. Next.
Grateful, grateful.
Not today, no, your lordship, not this week. Additional, sir, ওরা আছে আমি জানি না ধারা রমেশ আমি জানি না just দেখে নাও
Application can 2 is for addition of parties.
দেখে নাও
And can 1. This is your application. And petitioner is Mr. Agarwal.
petitioner না না অস্মিতা তোমার হ্যাঁ
Have you served the application upon Mr. Agarwal?
Shabnam,
Where are they? Whether they shall use affidavit against the application? No one is there. Okay, come on next week, 22.
ये तुम्हारा साइन है
Not this week.
झूठ नहीं हम लोग नाम ही नहीं पढ़ पा रहे हैं
Next.
22nd.
Not this week, only not this week. Only not this week. That means 22nd.
34 होगा अच्छी
Call next matter.
34. Lordship, in this matter, I am for the writ petitioner.
Led by Mr. Udarshankar Chattopadhyay, my lord engaged in another painful note.
Mr. Udarshankar Chattopadhyay is a petitioner here.
Lordship, I would like to say kindly come to your last order, that is on 17 June 2025. Opposition.
And
there is
one is the application for addition of parties.
Yes, Lordship, and I was crave leave to use opposition to submit opposition, Your Lordship.
Against all the applications.
Yes.
1, 2, 3, and 4.
3, Lordship. 4, yes. So, my lord, my humble prayer is now I need some more time to ready the opposition.
So there are 2 applicants.
Yes, my lord.
3 applicants? No, 2 applicants.
One is Rani Mollik.
Yes,
And
my
one
lord.
is
One is Don Raha and another is Rani Mollik.
both of them file application for vacating.
Rani Mollik.
Okay. So Mr. Chattopadhyay appears on behalf of both the applicants.
Yes, my lord.
So petitioner intends to use affidavit.
Yes.
Opposition.
Opposition. Another 10 days time, Your Lordship.
Please take down.
And Your Lordship, the last occasion, there is name Mr. Udarshankar Chattopadhyay, learned advocate for the petitioner. He was for the applicant.
Very good. Namta name for petitioner. Learned counsel, Namta name. What is your name?
Moushumi Chaudhuri.
Moushumi Chaudhuri appears on behalf of the petitioner and submits that the petitioner intends to use opposition against can application being can number 1, 2025, 2, 2025, 3, 2025, and 4 of 2025. He seeks some accommodation of a fortnight. Accordingly, the matter be adjourned today, list the matter on 30th of July 2025 under the same heading for hearing application.
I'm ready.
নামগুলো নিয়ে নিন।
আছে
মনে হয়
কখন? হ্যাঁ তারপরে দেখছি কোর্টের কাজ শেষ করে তারপর দেখছি এখন একটু দেখছি। Yes, next matter.
I am for the statement.
But I am for the applicant.
For the petitioner, my lord.
But there is a direction for filing affidavit to my application for addition of party and vacating application, my lord. Initially, the order was passed by my lord on 6th May. That was extended on 17 June, my lord.
But there are two applications filed by my lord. My lord. One, my lord, is for addition of party, my lord. Second, my lord, is for vacating of the interim order, my lord.
Can 1 and can 2.
Can, my lord.
Can 2, my lord. My lord, I must be candid, my lord. I'm in an embarrassing situation, my lord. It is done ready, my lord. It cannot be affirmed because the person who's supposed to affirm, my lord, he is unable to come to, my lord, Calcutta, my lord. My lord, my lord, so far as, my lord, the addition of party is concerned, my lord, let them be added as a party, my lord. I will not oppose it. So far as, my lord, vacating is concerned, lordship kindly extends it, my lord, for the last time. If, my lord, he is unable to come, my lord, I will do it without an affidavit of opposition.
So who filed the application?
Writ petition is mine, where I have obtained an interim order.
And addition of party by
is by, my lord,
by a candidate, my lord, in favor of whom the license was granted, my lord.
In favor of license. You are for the stay. So what is the status? He is running the license.
My lord, on 17th February, my lord passed the order. Kindly come page 26 of the application Can 1. Page 20.
License
Yes.
My lord, second paragraph. Last, considering the situations and considering the approach submission, state authorities at liberty to proceed with the selection process, but so far as the grant of license is concerned, the same shall not be issued till the disposal of such and such. The matter is pending before the division bench, my lord. Let the matter go out of list. My lord, on that day, my lord, no one are appearing state responding. We failed to appear, my lord.
Yes.
And my lord, license was issued as per my instruction, my lord. It was on 24th February. So my lord, no instruction was given to them, my lord, authority. They were, and my lord, subsequently on, my lord, 19 June, the license was revoked, my lord.
Revoked?
Yes. After coming to know the order of my lord, the order license was revoked on 19 June.
Okay. This is the status.
License is revoked.
Yes. Very good.
Okay. Please note. Mr. Hu, the learned counsel appearing on behalf of the petitioner, frankly submits that petitioners were directed to use opposition against Can 1 of 2025 and Can 2 of 2025. Full stop. The petitioner was is very sick, so he could not appear before this court. Accordingly, the opposition has not prepared. However, Mr. Huda frankly submits that the intending intervener is a person in favor of whom the respondent in favor of whom respondent authority earlier granted license. So he may be a necessary party in this proceeding, in this writ petition. Full stop. Learned counsel appearing on behalf of the respondent authority submits that this court has passed an interim order directing the respondent authority not to issue license till the disposal of appeals pending before the Honorable Division Bench being MAT 1543 of 2024. The state authority was unaware about the said interim order, but has issued the license in favor of the intending intervener on 24th of February 2025. After the state, full stop, after the state authority, thereafter the state authority had came to know about that order, and the license issued in favor of the intending intervener has been revoked by a specific memo. Considering the situation, it appears that the revoked dated in 19th June 2025. Revoked on by a specific memo dated 19th June 2025. This being the status of this matter, and the fact suggests that the petitioner has challenged the vacancy notification on the violations of clause on the violations of WPDS Maintenance and Control Order 2013. Thereby, it appears that the present petitioner, intending intervener, is a necessary party whose presence is requires to dispose of the matter. Accordingly, the intending intervener, namely,
লাউচর ফতেপুর সমবায় কৃষি উন্নয়ন সমিতি
লাউচর
লাউচর
ফতেপুর সমবায় কৃষি উন্নয়ন
কৃষি উন্নয়ন সমিতি, এই যে দেখো নামটা আছে এখানে সমিতি, be made party as a respondent number 5 of the instant writ petition. Under the above, the petitioner to incorporate the name in the cause title of the writ petition within a week. Full stop. As the petitioner, as the intending intervener has already appeared, the petitioner, no service is required to be made by the petitioner. Petitioner only to serve a copy of writ petition upon the petition, upon the respondent, added respondent number 5. Under the above petition, can of 2025 be disposed of?
Great.
Full stop. The petitioner is at leave to use the affidavit, use the opposition against can 2 of 2025 within a fortnight. Let the within a fortnight.
3 weeks.
Within 3 weeks, let the matter appear in the list on 12th of August.
Just one technical issue that I see, my lord. The management says, well, the license was not suspended. Should have been suspended, my lord.
Revoked.
So the one, it has been revoked. So perhaps my learned friend will have to, my lord.
That is the whole issue. You don't bother about that.
Own course of
You
action.
need not to bother about
Not in, perhaps not in this writ petition.
Very good. Okay.